The sitting is open. Good morning, dear colleagues. This morning, the agenda calls for the election of a judge to the European Court of Human Rights in respect of the United Kingdom. The list of candidates and biographical notice are to be found in document 16177. The opinion of the committee is presented in document 16198, the addendum 2. The voting will take place in the area behind the President's chair. At 1 p.m., I shall announce the closing of the poll. Counting will then take place under the supervision of 5 tellers who have been chosen by the political groups. The tellers are from the Socialist, Denis Begis from Sweden, EPP, Sergei Vlasenko from Ukraine, European Conservatives, Patriots and Affiliates, Axel Kassinger from Austria, Liberal Democrats, Lucia Plavakova from Slovakia, United European Left, Anne Graves from Ireland. I would like to remind them that they will have to be in the room set aside for this purpose at 1 p.m. The result of the vote will be announced at the beginning of this afternoon sitting. For these first ballots, an absolute majority of the votes is required. If a second round has to be organized, it will take place this afternoon from 4 p.m. to 6:30 p.m. I now declare the ballot open. We continue our work in the meantime. Before I move on, I remind the Assembly that members who have not submitted an annual declaration of interest are required to start any intervention with an oral declaration of interest under paragraph 20 of the Code of Conduct for members of the Parliamentary Assembly. I remind members that they should insert the badge before taking the floor. As you begin your speech, please press the microphone request button once only, wait for a couple of seconds and then start talking. I remind the Assembly that the Bureau has agreed that speaking times are limited to 2 minutes for all of today's debates. I will ask the Assembly to approve changes in the agenda for Wednesday, 25th June and Friday, 27th June. The debate on analysis and guidelines for a sustainable and socially fair energy transition is currently due to take place on Friday, 27th June. I propose to bring that forward to the afternoon sitting of tomorrow. Is that agreed? Yes, thank you. It is agreed and the agenda is amended accordingly.
Because we received President Zelensky.
Because, as I have announced here, since yesterday, we will receive President Zelensky at late hour. Before I go to the next item of business, I would like to refer to the day that we celebrate today. Today we celebrate Women in Diplomacy Day, an occasion to honor the women who shape international relations. From ancient emissaries to today's peace negotiators, women have long influenced diplomacy even when history left them unnamed. This day is both a tribute and a call to ensure their voices are fully included at every table. Yet globally, women remain underrepresented, as highlighted in our 2020 Assembly resolution on the gender dimension on foreign policy. Only about 21% of ambassadors worldwide are women, and they hold a small share of senior diplomatic positions. Progress exists, but parity remains distant. The Council of Europe tells a different story. With 20 of its 46 ambassadors being women, it reaches nearly 44% female representation, far above the global average. These women are not just statistics. They are exceptional diplomats with whom I've had the honor to work closely since the first day of my presidency. Their professionalism, insight, and friendship have strengthened our cooperation and inspired our shared commitment to democratic values. And it is a happy coincidence that we have the Maltese presidency. Malta, as you know, is represented by a woman as a diplomat, as an ambassador, who is at the same time the youngest amongst her peers. Now, the next item of business this morning is a current affairs debate on the European Court of Human Rights, rising to the challenges of our times. Speaking time in the debate is limited to 2 minutes for all members, except for one member chosen by the Bureau to open the debate, who is allowed 7 minutes. In the debate, I call first Lord Richard Keane. Lord Richard Keane, you have 7 minutes following the debate and then 3 minutes to respond. You may have the floor.
Thank you, Mr. President, colleagues. Montesquieu's seminal work on political science, The Spirit of Law, published in 1748, addressed his ideal constitutional model, which encompassed the separation of powers between a legislature, an executive, and a judiciary. This was the model for the United States Constitution and, in a looser sense, for the Council of Europe. The Council, of course, comprises a parliamentary assembly as a legislature, a committee of ministers as an executive, and the Court of Human Rights. And the democratic legitimacy of the latter as part of the Council of Europe is reflected in the role of this assembly in the election of judges. These elements should be able to work in harmony, but only if each respects its distinctive role and actually discharges its obligations under the Convention. The Court relies for its legitimacy, competence, and jurisdiction upon state consent. That is the consent of the state parties to the Council of Europe. That consent is conferred by the Convention and by the individual protocols that state parties have ratified. The role of the Court is to determine whether state parties have or have not complied with their obligations under the Convention and its relevant protocols, and enforce the rights conferred by the Convention and protocols. When it comes to the interpretation and application of the Convention, the Court, for at least the last 50 years, has treated the Convention as a living document, which must reflect current social, economic, and political attitudes, as well as developments in wider international law. To take one simple example, the perception of what constituted the right to family life in 1950 differs markedly from what it is today. However, the competence of the Court does not extend any further than the interpretation and application of the Convention and its protocols. It is not for the Court to innovate upon the rights and obligations consented to by state parties. Colleagues, the Court as a body and its individual members should not be the subject of attack by state parties for the decisions which it makes. That does not mean, of course, that the judgments of the Court should be free from criticism. The majority judgments of the Court are not infrequently the subject of criticism by judges of the Court themselves in dissenting opinions. A recent example was the dissenting judgment of Judge Eicher in the Swiss Old People's case. I happen to believe that Judge Eicher's criticisms were well-founded. I, of course, respect the majority opinion of the Court, but like a number of commentators, I happen to believe that the Court did exceed its jurisdiction and that this was an example of judicial activism. The President of the Court will, of course, disagree with me, as he's perfectly entitled to do. Colleagues, I now come to the open letter from the 9 state parties that has prompted this debate. I'm not entirely sure what is meant by an open letter, because I didn't receive it. I don't consider that the letter was the most appropriate mechanism for raising issues with respect to the competence and jurisdiction of the Court. But equally, I do not consider that it was intended, as suggested in the original title to this debate, as an attempt to undermine the Convention or as an attack on the independence and impartiality of the Court. It was an expression of exasperation with the migration issues perceived to be overwhelming many state parties to the Convention. It came from across the political spectrum, beginning with the Socialist Prime Minister of Denmark. Colleagues, if nothing else, it has acted as a catalyst by triggering this debate. The more neutral title adopted for this debate refers to the European Court of Human Rights rising to the challenges of our times. I personally believe that it should be the Council of Europe rising to the challenges of our times. The Court cannot be expected to do it on its own. One of those challenges is the uncontrolled migration into Europe aided and abetted by criminal gangs. If the terms of the present convention do not allow the domestic legislatures of member states to address this issue, then it is not the court but the convention and its protocols that require to be addressed. As I previously observed, the court relies upon state consent for its legitimacy, as expressed in the terms of those protocols and the convention. If state parties consider that the convention and its protocols no longer reflect their requirements for the proper protection of human rights, then the mechanisms for dealing with this are available, and they don't include an attack on the court. State parties can promote a further instrument to the convention which reflects what they regard as current attitudes to migration. I've no doubt that such a proposed instrument, whether in the form of guidelines, a protocol, or further convention, would be the subject of intense scrutiny and debate in this Assembly. If such an instrument was ratified, then it would be respected by the court in its application of convention rights. Such respect is, of course, mutual. If the court respects the terms of the convention and its protocols, then member states will respect its judgments and implement them, something that has been rather lacking in recent years. Colleagues, that brings me to my final observation. In order for the rights and obligations of the Convention and its protocols to work effectively, all three elements of the Council of Europe, the Assembly, the Committee of Ministers and the Court must work in harmony. And that, I fear, has sometimes been lacking. A perception of judicial activism makes some state parties reluctant to obey judgments of the Court. That, in turn, causes the Committee of Ministers to rarely, if ever, invoke Article 46. The machinery of the Convention then tends to grind to a halt. The open letter is therefore a wake-up call to the entire Council of Europe. Colleagues, many of you will have read that famous novel, The Leopard, by Tomasi de Lampedusa. I also recall one particular line attributed to the Prince of Salina as he faced the consequences of the risorgimento in Sicily. If we wish to remain the same, then some things will have to change. Thank you, President.
Thank you, Lord Keane. I call next Mr. Matthias Guillaumard, President of the European Court of Human Rights. And on this occasion, I want to welcome you to the Assembly and wish you all the best for your election in the years to come. You have 10 minutes, Mr. President.
Monsieur le Président, Monsieur le Secrétaire général, Mesdames et Messieurs les membres de l'Assemblée parlementaire, Mesdames et Messieurs les ambassadeurs, Mesdames et Messieurs, je suis profondément honoré de m'adresser à vous ce matin au sein de votre Assemblée dès le début de mon mandat de président de la Cour européenne. Élu pour un entier mandat de 3 ans, j'entends me placer dans la continuité de mes immédiats prédécesseurs, les présidents et présidentes Robert Spano, Shifra Oderi et Marco Bochniak. Je mesure l'atout que représente cette durée de 3 ans, qui est un gage de stabilité institutionnelle pour la Cour. Continuité et stabilité garantissent la cohérence dans le temps de l'action de la Cour. Nul besoin de rappeler devant vous le contexte difficile que nous traversons et les mises en cause dont fait l'objet le système de la Convention, auquel Lord Keane vient de faire référence, cette année même où nous fêtons les 75 ans de la signature à Rome de ce traité de l'humanisme juridique, expression de la volonté souveraine des États. Pour autant, la Cour est forte. Et je tiens à vous dire, Mesdames et Messieurs les parlementaires, à quel point ma détermination, mon engagement et mon optimisme puisent leur source dans cette solidité institutionnelle. La Cour est forte des 46 juges que vous avez élus. Par la variété de leur profil et la richesse de leur expérience, ils font de la Convention cet instrument vivant dont l'Europe a besoin. La Cour est forte des plus de 700 membres du greffe, placés sous l'autorité de Mariana Tsirli, dont je salue la présence, plus de 700 personnes dont les compétences et l'implication participent pleinement à l'activité et au succès de la juridiction. La Cour est forte du soutien des États membres, tel qu'exprimé lors du sommet de Reykjavik, à l'occasion duquel les chefs d'État ont rappelé la contribution extraordinaire du système de la Convention à la protection et à la promotion des droits de l'homme et de l'état de droit en Europe, au maintien de la sécurité et de la paix démocratique sur l'ensemble du continent. À cet égard, la Cour a su honorer la confiance placée en elle en faisant le choix historique de garder une juridiction résiduelle sur les affaires introduites contre la Fédération de Russie avant son expulsion du Conseil de l'Europe. Ayant ainsi décidé d'exercer sa compétence, la Cour est aujourd'hui la seule juridiction internationale devant laquelle la Fédération de Russie peut être tenue pour responsable des violations de droits et libertés protégées par la Convention. Sur 16 000 affaires pendantes en 2022, la Cour en a déjà réglé plus de la moitié. Et le 9 juillet prochain, elle rendra un arrêt dans les affaires interétatiques Ukraine et Pays-Bas contre Russie. C'est à ce moment charnière que débute mon mandat de président. Et pour relever les défis de notre temps, je l'ai placé sous le signe de la responsabilité partagée autour des 3 priorités suivantes: efficacité, visibilité, responsabilité. Efficacité. De nombreuses réformes ont été engagées ces dernières années qui ont permis de sensiblement améliorer la productivité, notamment grâce à une priorisation fine des affaires. Et nous avons ainsi ramené notre stock d'affaires pendantes à environ 60 000. Je rappelle que depuis sa création en 1959, la Cour a réglé judiciairement plus d'1 million d'affaires. Toutefois, nous devons encore progresser en matière d'administration de la justice. Notamment, la Cour met encore trop de temps à juger les affaires les plus complexes. Et je m'engage à améliorer la situation au cours des 3 années qui viennent en tentant d'atteindre un objectif concernant les affaires de chambre de délai moyen de jugement entre 2 et 3 ans. Visibilité, c'est le deuxième axe. Transparence et accessibilité sont aujourd'hui indispensables pour gagner la confiance des interlocuteurs de la Cour. Nous devons réussir à nous adresser à 3 cercles de personnes en même temps. Le premier cercle comprend naturellement les parties au litige, mais aussi tous les acteurs institutionnels du Conseil de l'Europe, dont la Cour est l'organe judiciaire. Le deuxième cercle est constitué par les autorités nationales des États membres, en particulier les juridictions internes, mais aussi les partenaires habituels de la Cour, les avocats, les ONG et les relais d'opinion tels la presse ou les réseaux sociaux. Enfin, le troisième cercle comprend l'opinion publique, la population, les gens qui portent leur vie devant notre prétoire et auxquels nous nous devons d'expliquer mieux notre rôle. Responsabilité enfin. La force de l'état de droit repose, y compris à l'échelle européenne, sur le principe cardinal de l'indépendance judiciaire. Je peux vous assurer que, tout au long de mon mandat, je m'emploierai avec vigueur et détermination à garantir la pleine indépendance de la Cour et de ses juges. Et comme l'a rappelé hier dans son discours le président Ronzopoulos, l'histoire nous a montré que lorsque le pouvoir politique interfère avec la justice, c'est la démocratie qui en paye le prix. Mais il n'est d'indépendance valable sans responsabilité. Assumer ses responsabilités juridictionnelles sans crainte ni faille implique de savoir rendre des comptes. Il y a 75 ans, les pères fondateurs nous ont confié la charge d'assurer la sauvegarde et le développement des droits humains et des libertés fondamentales. Qu'il s'agisse de l'interprétation ou de l'application de cette convention, nous devons nous expliquer sur notre mission judiciaire. Nous devons nous expliquer sur ce que nous avons fait et sur ce que nous faisons de ce legs à la fois précieux et fragile. À cet égard, je m'attacherai à renforcer les liens qui existent déjà avec le Conseil de l'Europe et en particulier avec votre Assemblée. Face aux défis auxquels elle fait face et aux critiques dont elle fait l'objet, efficacité, visibilité, responsabilité sont les conditions indispensables de la légitimité de la Cour. Mais celle-ci puise aussi ses racines dans la responsabilité partagée et le principe de subsidiarité sur lequel reposent les relations entre les autorités nationales et la Cour, dont je ne rappellerai jamais assez qu'elle ne doit intervenir qu'à son tour, après l'épuisement des voies de recours internes et à sa place, dans le respect de la biodiversité historique, politique et juridique qui fait la richesse de notre Europe. À l'heure où se développe un populisme anti-judiciaire, pour reprendre les termes éloquents de Lord Reed dans son discours prononcé à Inner Temple le 12 juin dernier, je veux dire ici, et ici, dans votre hémicycle, qu'opposer les juges à la démocratie constitue un contresens absolu. Et je saisis l'occasion qui m'est donnée aujourd'hui de m'exprimer devant vous, mesdames et messieurs les parlementaires, pour souligner le rôle essentiel que jouent les juges dans le soutien et la protection de la démocratie. Ce lien est inscrit dans le préambule de la Convention, qui rappelle que le maintien des droits humains repose essentiellement sur un régime politique véritablement démocratique. Vous êtes le moteur politique de l'organisation. Vous incarnez l'indispensable pont entre le Conseil de l'Europe et les États membres. Et je veux redire devant vous l'irremplaçable source de légitimité que constitue pour les 46 juges de la Cour le fait d'avoir été élus par votre Assemblée. Je rappelle que depuis 2021, vous avez procédé à l'élection de 22 juges. C'est une garantie démocratique qui nous conforte et nous oblige. La Cour est un légitime objet de débat politique, mais elle n'est pas un acteur du débat politique. C'est d'abord par ses arrêts qu'elle s'exprime, la qualité de son travail, la rigueur de ses raisonnements, l'équilibre de ses solutions. Et s'agissant de la séparation des pouvoirs et de l'exacte restitution du rôle judiciaire de la Cour, c'est dans l'arrêt climat dont il vient d'être parlé, du 9 avril 2024, qu'au paragraphe 412 se trouve exactement décrit la complémentarité entre la compétence des juridictions et les autres processus démocratiques. 4 points à cet égard. Les juges, d'abord, sont les remparts contre l'arbitraire, en veillant au respect des formes et des procédures et en exerçant un contrôle externe indépendant. Les juges sont les gardiens de la part indisponible des droits humains. Ensuite, ces droits absolus qui ne souffrent aucune dérogation, comme la dignité humaine protégée par l'article 3. Ces droits qui sont indisponibles aux majorités du moment, car ils sont sanctuarisés au plus profond de la personne humaine. Les juges sont les garants du respect du pluralisme, du droit des minorités et des personnes non représentées. Et pour la première fois dans l'arrêt du 9 avril 2024, la Cour a consacré la notion d'intérêt des générations futures, alors même qu'elles ne sont pas actuellement représentées. Cette capacité à se faire le juge du futur m'amène à mon 4e et dernier point. Les juges sont les dépositaires d'une certaine forme de temporalité démocratique. Le temps de l'élection, le temps de l'action politique ne sont pas le temps de la justice. Ils doivent se compléter et non s'affronter, et le populisme se nourrit des collisions entre ces temporalités. Le juge saisi de litiges déjà noués porte par nature un regard rétrospectif sur la question en jeu. Il peut aussi, en tranchant le cas particulier dont il est saisi, définir des règles générales, appelées à être mises en œuvre dans le temps long. Mais je le dis ici devant vous, mesdames et messieurs les parlementaires, le juge ne saurait faire œuvre de législateur. La Cour le rappelle avec constance, les autorités nationales jouissent d'une légitimité démocratique directe et se trouvent en principe mieux placées que le juge international pour se prononcer sur les besoins et contextes locaux. Et s'agissant du législateur, la Cour souligne de manière bien établie l'importance de la qualité de l'examen parlementaire qui entre en ligne de compte dans l'application de la marge d'appréciation. Pour conclure, je veux rappeler ici avec conviction que la déférence du juge envers le Parlement, qui adopte la loi dans l'intérêt général, loin d'affecter son indépendance, renforce sa légitimité dans le cadre d'une séparation des pouvoirs bien comprise. C'est ainsi, en veillant à ne pas dépasser les limites de son rôle judiciaire, que la Cour peut remplir au mieux son office, à la fois pleinement autonome dans l'interprétation de la Convention telle qu'elle est, et soucieuse du contexte dans lequel elle intervient. C'est la condition de la protection effective des droits humains posés dans la Convention et des valeurs sur lesquelles elle repose, et c'est ainsi que pourront prévaloir les idéaux de paix et de justice. Je vous remercie pour votre attention.
Thank you, Mr. President. Dear colleagues, we will now hear speeches from the speakers on behalf of the political groups. I remind members that speaking time is 2 minutes. On behalf of the Socialists, Greens and Democrats, Christophe Lacroix has the floor.
Monsieur le Président, mes chers collègues, devons-nous ignorer que des dirigeants cherchent à affaiblir la Convention européenne des droits de l'homme? Devons-nous ignorer que des dirigeants s'attaquent à l'indépendance et à l'impartialité de la Cour européenne des droits de l'homme? Devons-nous accepter que l'instance qui offre la protection la plus avancée au monde des droits humains soit aussi facilement et ouvertement, à travers la presse, remise en question et délégitimée? Nous faisons face ici à une urgence indubitable. Les enjeux migratoires qui se présentent à nos pays sont instrumentalisés pour fracturer nos institutions démocratiques et nos valeurs les plus fondamentales. Mais rien ne justifiera jamais de revenir sur l'interdiction totale et absolue de la torture. Rien ne justifiera jamais d'outrepasser l'état de droit. Rien ne justifiera jamais de remettre frontalement en cause le pouvoir judiciaire. Pourtant, c'est justement ce que les signataires de cette lettre promeuvent. Ils demandent une modernisation de la Cour, l'augmentation de la marge de manœuvre des États en matière migratoire ou encore d'accroître le suivi des étrangers inaptes à l'expulsion. En définitive, la Cour ne serait ni indépendante ni impartiale et répondrait à un prétendu agenda politique. Mais ce qui me révolte, c'est la méconnaissance totale dans cette lettre du fonctionnement de la Cour. 1. La Cour est le rempart le plus vital des droits humains. Elle est, après nos États, une seconde couche de protection indispensable de ces droits. 2. L'interprétation fait par nature partie de la fonction d'un juge. La Convention est un outil vivant que les juges doivent interpréter dans la conjoncture face au contexte actuel et aux enjeux d'aujourd'hui. Les juges doivent être impartiaux, mais pas neutres. 3. Les juges ne répondent pas à un agenda politique déterminé. Par ailleurs, ils sont parmi les rares juges élus. Et enfin, 4. La Cour laisse déjà une marge de manœuvre importante aux États pour légiférer, y compris en termes de politique migratoire. Chers collègues, en ces temps sombres, notre seul sacerdoce est de faire entendre notre vive indignation face à ces redoutables tentatives d'affaiblir la Cour européenne des droits de l'homme et, à travers elle, l'ensemble des droits humains. Je vous remercie.
Thank you, Christophe. On behalf of the EPP, Ronan Mullen.
Mr. President and friends and colleagues, the European Convention and the European Court of Human Rights are the jewels in the crown of the Council of Europe institutions. That idea can unite us all, but this open letter written by 9 member states of the European Union has really led the Court and indeed the Council of Europe to arrive at what we might call a crisis moment, but also, to borrow a term from the ancient Greek, a kairos moment, a critical or opportune time for decision or action, because the letter demonstrates that the Council of Europe has been unable to resolve an important issue through the normal internal negotiation channels. If one recalls only the Lautsi case, where member states were unhappy with the direction being taken in the Court's jurisprudence in a forum in which the Court was an observer, the message got across. But this painful and delicate moment is one where it almost seems like the dirty laundry is being washed in public. And this is delicate because the independence and the perception of the independence of the Court is vital. But also, while the Court must always be beyond interference, it can never beyond scrutiny, as others have said. And perhaps now is the time for healthy pruning and reform. And I would offer a couple of principles here this morning, that in the appointment of judges, careful attention must be paid to the curriculum vitae of applicants. We had controversy some years ago about the disparity between a submitted CV and the facts of whether an appointed judge had a past career as a licensed advocate. So it's up to us as the Parliament to give to the Court judges who have experience of impartial adjudication in the Member States. Avoiding conflicts of interest will also be important. Perhaps the role of NGOs may need to be scrutinised, and declarations of interest by candidates and judges may be something that is timely. I note some of the recommendations made by the European Centre for Law and Justice in 2 reports in 2020 and 2023 are perhaps worthy of consideration at this time. And perceived consistency in decision-making by the Court as well. These are among the principles. It is friends in the end who criticise, with a view to enabling the Court fulfil its important function. And now may indeed be a time for reform, not just to the Convention, but a healthy reflection on the composition of the Court and how it does its work as well. And in that important task, we should all be involved.
Thank you. Colleagues, I know it's difficult, but you have to stay on 2 minutes limit. On behalf of the European Conservatives, Patriots and Affiliates, Elisabetta Gardini. Elisabetta.
Grazie, signor Presidente. Desidero prima di tutto ringraziare il Presidente della Corte per il suo intervento e anche il collega Lord Keane per il contributo importante che ha dato alla discussione. È un confronto importante che arriva in un momento delicato per le nostre democrazie. Ma la lettera aperta, firmata il 22 maggio da 9 capi di Stato e di Governo, propone una riflessione di alto livello sulle grandi convenzioni internazionali, non per indebolirle, come qualcuno ha interpretato, ma proprio per rafforzarle. Perché renderle più aderenti alla realtà di oggi significa proprio proteggerne il valore e garantirne l'efficacia anche in un mondo che è profondamente cambiato. Dobbiamo ricordarci che queste convenzioni sono nate in un'epoca totalmente diversa, era il secolo scorso, era dopo il secondo conflitto mondiale, quindi un contesto completamente diverso da quello attuale. Oggi le nostre società si confrontano con sfide nuove, complesse, globali, a partire dal fenomeno migratorio che, come è già stato ricordato, incide sulla sicurezza, sulla coesione sociale, sulla capacità degli Stati di rispondere in modo giusto ed equilibrato. E bisogna ammettere che in alcuni casi l'applicazione di principi che sono, e lo sottolineo, sacrosanti, ha generato esiti difficili da capire, anche per l'opinione pubblica, soprattutto per la pubblica opinione. Penso ad esempio a decisioni che hanno impedito l'espulsione di stranieri condannati per crimini gravi. Ecco, proprio per questo ritengo giusto e doveroso aprire una riflessione seria, il mio gruppo lo ritiene importante, che ci permetta di verificare se gli strumenti giuridici a nostra disposizione siano ancora proporzionati, efficaci, adeguati alle sfide del presente. Quindi non si tratta di mettere in discussione i valori che le convenzioni incarnano, ma di rafforzarli. Ringrazio il segretario generale Alain Berset che tra le tante cose che ha detto anche che non ci devono essere tabù, perché secondo noi il vero pericolo per i diritti fondamentali non è il confronto, ma il dogma. E quando il diritto si chiude alla realtà, che perde la sua forza e la sua legittimità. Vi ringrazio.
Thank you, Elisabetta. On behalf of the Liberal Democrats, Bertrand Wicks. Bertrand, you have the floor.
Merci, Monsieur le Président, chers collègues. Face aux menaces qui pèsent aujourd'hui sur l'indépendance de la Cour européenne des droits de l'homme, nous avons une responsabilité collective, celle de défendre avec fermeté le système de la Convention, socle de notre engagement commun au sein du Conseil de l'Europe. Les critiques récentes, émanant notamment de dirigeants européens qui mettent en cause la jurisprudence de la Cour, ne sont pas anodines. Elles ne relèvent pas d'un simple débat juridique, elles s'inscrivent dans une stratégie politique dangereuse, celle qui, sous couvert de préoccupations sécuritaires et migratoires, vise à affaiblir l'autorité de la Cour, à remettre en cause l'interprétation de la Convention et plus largement à éroder les garanties fondamentales des droits humains. Comme l'a justement rappelé notre secrétaire général Alain Berset, ce n'est pas à la politique de dicter le droit et encore moins d'en menacer les institutions. C'est précisément dans les moments de tension que l'on mesure la valeur de l'état de droit, quand les principes résistent à la pression des agendas populistes. La CEDH est l'un des piliers les plus solides de notre ordre démocratique européen. Elle garantit à chaque citoyen une protection indépendante au-delà des majorités politiques passagères et des frontières nationales, et vous l'avez très bien rappelé, Monsieur le Président Guillaumard. Ce que nous défendons ici, ce n'est pas une institution isolée, c'est l'idée même que les droits fondamentaux ne sont pas négociables, que l'interprétation de la Convention ne peut être dictée par les gouvernements et que la coopération multilatérale reste notre meilleure arme contre les dérives autoritaires. Alors oui, ouvrons ce débat, documentons les menaces, nommons-les clairement et surtout réaffirmons sans ambiguïté notre attachement à l'indépendance de la Cour, à la force contraignante de ses arrêts et à l'unité du système de la Convention, car affaiblir la CEDH, c'est affaiblir l'Europe, et cela, nous ne l'acceptons pas. Merci.
Thank you, Bertrand. On behalf of the United European Left, Sonnen Sondergaard. Sonnen.
Thank you. Some countries have sent an open letter demanding a change in the practice of European Court of Human Rights. One of these countries is my own country, Denmark. Let me start by stating the Danish government does not speak in my name, and it does not speak in the name of all the Danes either. The letter tries in a sophisticated way to imply that foreigners can come to Europe and commit crimes with impunity. This is not the case. No ruling from the European Court of Human Rights has ever prevented criminals from being punished, and punished hard, regardless where they come from, just like any other citizens in our countries. But what is the real problem when we look at the world today? It is that human rights are too widespread, or that they are respected too much? No, just the opposite. Human rights and international law are under pressure everywhere. From Trump in US, from Putin in Russia, from the Ayatollahs in Iran, from Netanyahu in Israel, but also here in Europe. Just think of Kavala and Demirtas in Turkey, who have been imprisoned for years, despite the clear demands for their release from the European Court of Human Rights. We are looking forward to participate in a discussion about European Court of Human Rights. We are also looking forward to discuss all kinds of arguments, but it should start by addressing the real problems. The waiting time at the court is far too long, and the court has far too little power to implement its decisions. From our group, the United European Left, we do not want human rights to apply to fewer people. We want more human rights to apply for all people. Thank you.
Thank you, Soren. We continue with Pierre-Alain Fridet. Pierre-Alain. Pierre-Alain, we cannot hear you. Have you inserted your badge?
C'est bon. Merci, Monsieur le Président. Je ne peux m'empêcher de penser que le rapport contesté sur les expulsions collectives que j'ai présenté en avril dernier dans cet hémicycle est peut-être en partie à l'origine de la lettre des 9 pays qui ont réclamé une évolution dans certaines décisions de la Cour européenne des droits de l'homme. Pour des motifs émotionnels en ce qui concerne certains pays proches de la Biélorussie, avec sa guerre hybride, ou pour des motifs politiques pour d'autres, les parlementaires de ces pays ont contesté, lors de ce débat, la ligne rouge que représente dans tous les cas le droit absolu pour chaque migrant de pouvoir bénéficier d'une évaluation individuelle de sa propre situation, avec protection et respect de ses droits. Et si renvoi il doit y avoir, cela ne sera que vers un pays tiers sûr. Nos différents pays ne peuvent réclamer un traitement à la carte selon leur agenda national. La CEDH représente le socle de nos valeurs, elle nous oblige et la séparation des pouvoirs est essentielle. Merci.
Thank you, Pierre-Alain. Petra Bayer is next. Petra.
Yeah, thank you very much. The court interprets the convention and that makes it to a living document. And since its entry into force, for instance, Article 14 on anti-discrimination was developed tremendously. And we are also now all witnesses of an emerging right to live in a healthy, clean and sustainable environment. This development, of course, is important as it reflects social progress. And also debates about the interpretation are legitimate if they are serious and if they uphold the values and the protection of the human rights. A letter of 9 addressed to nobody is maybe more a piece of domestic policy than a constructive contribution to the further development of the convention and of the decisions of the court. It is more a signal of the category Fortress Europe than a contribution to foster human rights and to really make them strong. And I very much share the thoughts and the visions the President told us for the court, for the work of the court, for the convention as such. And I think what we as Assembly really can do and will do is to promise that we really do our utmost to elect the best judges possible. You know, we are working on some further developments on how we make this progress really smoothly, how we also already start at the national selection procedures to have really these judges in the court at the very end that really have an understanding of the values and of the core principles of the Convention of us as a European Council of Europe. And I think that is a good cooperation that we have. Thank you very much for all your contributions to us. I think it's a great dialogue, and I'm sure that we will foster the convention in a way that it cannot be undermined by whoever. Thank you very much.
Thank you, Petra. Christophe Bricot. Christophe.
Merci, Monsieur le Président. Le débat qui nous occupe aujourd'hui est presque un paradoxe. Sur le fond, il y a la question migratoire, qui est une question qui traverse la plupart de nos pays et qui a tendance à faire monter les populistes qui sont les premiers à attaquer souvent l'indépendance de la justice, indépendance de la justice qui est un des fondements de l'État de droit et de la Cour européenne des droits de l'homme, qui nous est précieuse. Double indépendance presque dans le cas de la Cour européenne, puisqu'il y a l'indépendance de la séparation des pouvoirs, mais il y a aussi sa formation de 46 juges issus de 46 États, ce qui fait que le juge qui juge un État n'est pas celui issu de cet État, et donc il est doublement indépendant par rapport à l'État jugé. Maintenant, j'aimerais en appeler à notre responsabilité, puisque le président Guillaumard a appelé à celle de la Cour européenne. Nous élisons les juges. Nous sommes responsables de la composition de la Cour. Nous défendons la Convention européenne des droits de l'homme. C'est la Cour qui l'applique, pas nous. C'est la Cour qui, au cas par cas, décide comment cette Convention s'applique aux citoyens de nos États. Donc nous devons être attentifs, en particulier dans cette maison où nous défendons la démocratie, l'État de droit et les droits et libertés fondamentaux, et en particulier dans ce cas-là, l'État de droit, à veiller à l'indépendance de la justice, à la séparation des pouvoirs, la hiérarchie des normes, qui est aussi un élément de l'État de droit. Et je crois que nous devons faire attention dans nos discours, sans omettre, je répète, la question migratoire, qui est un vrai sujet, à préserver ce joyau, comme le disait mon collègue, de notre institution. Je vous remercie.
Thank you, Christophe. Sigrid Andersen is next.
Yes, Mr. President, I welcome the initiative of the 9 European leaders taken with the written statement on the capacity of the ECHR and the interpretation of the European Convention on Human Rights. The statement refers to judgments of the court solely in one specific area, namely in regard to migration. I would like to take this opportunity to draw your attention to other important factors to be considered. Well, the ECHR, the court, operates quite differently than regular courts that most of us know from within our countries, and even transnational courts like the European Court of Justice and the EFTA Court. The procedures with the EFTA Court, with the European Court of Justice, with the European Court of Human Rights, I was going to say, mainly how it reaches its conclusions, how it decides on which cases to hear and which not, is not compatible to other courts. Even the election or the leading up to the election of the judges is not beyond doubt, in my opinion. This is important to bear in mind when debating the role of the court in setting precedent, let alone inventing new rules. The European Court, the European Court of Human Rights, has been reluctant to interfere with the assessments of national courts, particularly when it comes to discretionary decisions or the interpretation of the domestic law. Fine. But this principle is in retreat. Even this principle is in retreat. The ECHR has not only been interfering with decisions taken by the executive branches of member states, as in the migration cases, it has also disregarded democratic decisions taken at the legislative level. In Iceland, for example, we have a case of the ECHR concluding as unlawful some lawful decisions taken by the parliament in Iceland, Alþingi, on the appointment of 15 national judges at a newly established court, decisions taken fully in concordance with law and confirmed by the Supreme Court of Iceland. I emphasize that if one is of the opinion that human rights varies with time, which I certainly am not, it's not my opinion, it must be the task of those democratically elected to ratify those rights and amend the European Convention on Human Rights.
Thank you. Damien Gauthier is next.
Merci, Monsieur le Président. D'abord, merci pour ce débat. La Cour européenne des droits de l'homme est effectivement un instrument indispensable à la garantie de la démocratie et des droits de l'homme sur notre continent et à cette architecture telle qu'elle a été créée après la Deuxième Guerre mondiale. Et donc, remettre en cause par principe l'indépendance ou l'impartialité de la Cour est quelque chose que nous ne pouvons pas accepter. Et c'est le rôle de cette Assemblée d'en débattre et de défendre la Cour dans son rôle, de défendre aussi l'application de ses arrêts. Notre Assemblée s'y intéresse régulièrement et de consacrer, ça a été dit par plusieurs préopinants, toute son énergie et peut-être encore plus d'attention qu'aujourd'hui au processus très important d'élection des juges, tel que nous y procédons d'ailleurs aujourd'hui. Et pourtant, dans ce débat, il faut, je sais que le monde actuel ne l'aime pas trop, mais il faut aussi avoir une position nuancée. Le droit à la critique existe, et je fais partie de ceux, et probablement effectivement, comme l'a dit le président de la Commission tout à l'heure, que le président de la Cour, il l'a évoqué, n'aura pas le même avis, je suis de ceux qui estiment que la Cour est allée trop loin dans certains cas, comme dans le cas de l'arrêt Clima Seniorinen contre Suisse, qui a été évoqué plusieurs fois. En modifiant sa jurisprudence sur certains points, la Cour a interprété de manière très extensive la notion d'instrument vivant de la Convention, et ce faisant, elle fait un pas qui va dans la direction d'un certain activisme judiciaire. Et ça, il faut absolument l'éviter, de manière à préserver la confiance et la crédibilité de la Cour. Au fond, c'est parce qu'on a un attachement très fort à la Cour et à son rôle qu'il faut faire attention qu'elle n'aille pas trop loin. Et c'est la raison pour laquelle les deux chambres du Parlement suisse ont très récemment adopté une motion qui invite le gouvernement à discuter avec les autres gouvernements de la possibilité d'un 17e protocole additionnel pour cadrer davantage sur les points sur lesquels il y a peut-être là des pas de trop qui ont été effectués. Je crois que c'est la manière légitime de faire le débat politique, le rôle du politique que de débattre du cadre, et ensuite le rôle de la Cour que de décider dans des cas concrets de manière totalement indépendante. En procédant ainsi, nous serons dans la logique même de la séparation des pouvoirs et donc la responsabilité qui est liée à l'indépendance qui a été évoquée tout à l'heure par le Président. Je vous remercie.
Thank you, Damien. Benjamin Dahl. You're next, Benjamin.
Thank you, Mr. President, dear colleagues, Monsieur le Président de la Cour européenne des droits de l'homme. Let me first start by thanking those who initiated this debate, in particular my Belgian colleague, Christophe Lacroix. It comes at a crucial moment. Everywhere in the world, we are witnessing a troubling trend, growing political interference with independent institutions, including the judiciary. The European Court of Human Rights, as the guardian of the Convention, is increasingly the target of that pressure. The open letter, co-signed by 9 European leaders, including the Belgian Prime Minister, openly questions the Court's authority and interpretative role. As the Belgian parliamentarian, I believe it is important to express a different view, one that firmly reaffirms the essential role of the Court within our democratic and legal order. In the letter, one sentence in particular stands out. Quote, "We believe that the development of the Court's interpretation has, in some cases, limited our ability to make political decisions in our democracies." That framing, dear colleagues, suggests that rights and democracy are somehow in tension, in contradiction. But in truth, rights are not limits on democracy. They are what makes democracy legitimate, what makes democracy worth fighting for. When judicial oversight is framed as an obstacle to political action, we risk hollowing out the very principles we claim to protect. The Court's independence is not a threat to national sovereignty, but a safeguard against its abuse. And when that independence is challenged, this Assembly must respond with clarity and unity. Let us stand by this legacy together, firmly, calmly, and
Thank
together.
you.
Thank you.
Axel Kassinger is next.
Vielen Dank, Herr Präsident, geschätzte Kolleginnen und Kollegen. In einem Brief haben 9 Regierungschefs ihre Sorgen hinsichtlich der Spruchpraxis des Europäischen Gerichtshofs für Menschenrechte geäußert. Ich zitiere: There is a need to look at how the European Court of Human Rights has developed its interpretation of the European Convention on Human Rights, whether the court in some cases has extended the scope of the Convention too far as compared with the original intentions behind the Convention, thus shifting the balance between the interests which should be protected. Zitat Ende. Das heißt, was waren die originären Intentionen der Menschenrechtskonvention aus dem Jahre 1953? Doch der Schutz der Interessen europäischer Bürger vor den Übergriffen des Staates, vor willkürlichen Verhaftungen, vor Einschränkungen der Meinungsfreiheit etc. Ich als Politiker der Freiheitlichen Partei Österreichs, der stärksten Partei in Österreich mit 30% fast Wähleranteil, begrüße das Begehren in diesem Brief. Ich begrüße, dass damit 9 Regierungschefs diese Diskussion angestoßen haben. Ich begrüße explizit, dass auch unser Bundeskanzler der Republik Österreich diesen Brief unterfertigt hat. Und ich begrüße 2 wesentliche Botschaften dieses Briefes, nämlich erstens: Die demokratisch gewählten Regierungen souveräner Staaten dürfen in ihren Entscheidungen, illegale oder straffällig gewordene Migranten abzuschieben, nicht über Gebühr eingeschränkt werden. Und die zweite Botschaft, wo es um die Prioritäten geht, die schutzwürdigen Interessen, die Sicherheit und Stabilität unserer eigenen Gemeinschaft hat die höchste Priorität.
Thank you, Axel. Piero Fassino. Piero, you have the floor.
Grazie Presidente. Io credo che questo dibattito sia minato da un equivoco. La lettera dei 9 capi di governo e di Stato evoca un conflitto tra la sovranità nazionale e la Corte europea, sostenendo sostanzialmente che la Corte europea nelle sue interpretazioni mina, lo ha detto adesso il collega austriaco, la sovranità nazionale dei singoli paesi. Io credo che non sia così. Credo che la Corte europea di giustizia è stata creata, dei diritti umani, è stata creata per tutelare i cittadini, tanto è per garantire l'uguaglianza di trattamento di tutti i cittadini dei paesi che sono membri del Consiglio d'Europa. E il rispetto della sovranità è assoluto, tanto è vero che, come ha ricordato il Presidente della Corte, la Corte interviene soltanto dopo che nella giurisdizione interna siano stati esclussi tutti i gradi di giudizio. E quindi da questo punto di vista non è davvero vero che l'attività della Corte mette in discussione la sovranità nazionale. In realtà i diritti non sono una variabile. Non è che i diritti cambiano a seconda delle maggioranze politiche. Le maggioranze politiche che sono democraticamente elette hanno diritto di elaborare, proporre e far approvare i provvedimenti legislativi che corrispondono ai loro programmi, ma non possono questi provvedimenti legislativi essere contro fondamentali diritti di uguaglianza e di rispetto della titolarità dei cittadini. E io credo che questo sia il problema. E noi dobbiamo garantire quindi l'indipendenza della CEDU e la sua attività, proprio per garantire i cittadini, perché è a tutela dei cittadini che è stata creata molti anni fa la Corte e non a tutela degli Stati nazionali. E quindi io penso che si può discutere di tutto, la discussione non è mai negata, e quindi discutiamo anche delle cose che vengono evocate in quella lettera, ma sapendo che le nostre società oggi non sono più deboli perché ci sono troppi diritti. Le nostre società oggi sono più deboli perché spesso i diritti non vengono tutelati e rispettati.
Agnes Sirka, Primary is next. Agnes.
Thank you, Mr. President. Honorable colleagues, when I first studied the European Convention on Human Rights, it felt like a promise of that dignity, freedom, and justice are not only ideals, but enforceable rights. That promise is still powerful, but it is not self-fulfilling. It depends on us. Human rights are not automatic. They must be defended, especially when they become politically inconvenient. They are the last safeguards. And that is why attacks on the independence of the European Court of Human Rights by some governments, unfortunately, including mine, they are so dangerous. Weakening the court weakens the rights of all of us. We all know that a convention is the result of a process, and this process of development must continue. But there is a legitimate way to do so, through court's interpretation and through protocols and conventions agreed by all of the states. If we bypass that, we risk eroding the rights we claim to stand for. Let's be honest, defending human rights is not always the easy path. But the easy path never led to justice. By ratifying the convention, our states committed not only to its rights, but to its principles. Above all, the rule of law and the separation of powers. These are the structures that protect us from arbitrariness. And they are what turn ideals into guarantees. Colleagues, we did not inherit these standards for free. They were hard fought, often in face of tyranny, war, and injustice. And now it's our responsibility to protect them and strengthen them. To do otherwise is to betray those who came before us and those who count on us today. Thank you.
Thank you, Anis. Marco Driosto, Marco.
Okay. Prendo spunto, Presidente, da questo importante dibattito per parlare delle vergognose, offensive, ideologiche dichiarazioni rivolte dalla Commissione contro il razzismo e l'intolleranza al Consiglio d'Europa alle forze dell'ordine italiane del nostro Paese. La Corte europea dei diritti dell'uomo, di cui oggi parliamo, ha certamente il compito di valutare fatti oggettivi, ma queste parole sono allusive e noi le respingiamo al mittente. Oltretutto, signor Presidente, minano la credibilità delle istituzioni europee. Offendere le nostre forze dell'ordine significa colpire uomini e donne che ogni giorno rischiano la vita per proteggere quella degli altri. Lo ricorda anche, lo ha ricordato recentemente, il nostro Presidente della Repubblica Sergio Mattarella, che ha messo parole chiare a difesa della professionalità, della dedizione e del ruolo insostituibile della Polizia italiana a tutela della democrazia e della legalità. Io ritengo, Presidente, lo dico anche al Presidente della Corte di Giustizia, che serva una vera e profonda riflessione su queste commissioni, ma forse più in generale anche sul ruolo del Consiglio d'Europa. Se deve essere utilizzato come una clava, ripeto, una clava per attaccare governi che sono non graditi alla sinistra da salotto, allora forse è il momento di rivedere anche concretamente la nostra partecipazione, e questi soldi evidentemente che si andranno a risparmiare potranno essere utilizzati proprio per le forze dell'ordine che sono sempre a servizio del Paese per la nostra difesa. Grazie.
Gala Beldochen is next.
Thank you, Mr. President, colleagues. The recent joint statement by the 9 EU and Council of Europe member states is a dangerous attack on the rule of law and democracy. Under the guise of border control and public safety, it questions the court's interpretation of the convention, which undermines the rule of law and separation of powers. The court exists to protect individuals against the arbitrary use of state power. Its role is to interpret the convention, an agreement designed to ensure legal protection for all. Attempts to influence the court's jurisprudence through political pressure rather than formal treaty amendments sets a dangerous precedent. Today, the pressure is focused on migration. Tomorrow, it could target anyone who challenges state authority. This is not a legal reform. It's a political assault on a body that holds governments accountable. Allowing states to pick and choose which rulings to respect weakens legal safeguards against discrimination and oppression. We urge all Council of Europe member states to defend the court's independence and the principles it embodies. We also call on the European Union to accelerate its accession to the European Convention of Human Rights. The EU have to stand with us. This would create a unified legal space where the court can review EU decisions for human rights compliance, including in migration matters. In this time of coordinated political pressure, not only we as the Council of Europe, but also the EU must take a firm and unequivocal stance for human rights, for judicial independence and the rule of law, for its member states and also for itself. So we build a stronger Europe. Thank you.
Thank you, Carla. Pierre Lamely is next. Have you inserted your badge? Because I don't see your name in the computer. Have you inserted your badge? Have you inserted your badge first? You are not connected. Now you are connected. You can press the button and start talking.
Ja, danke, Herr Präsident. Sehr geehrte Damen und Herren, die Gewaltenteilung ist eine zentrale Grundlage jeder Demokratie. Doch was wir derzeit erleben, ist eine gefährliche Schieflage. Der Europäische Gerichtshof für Menschenrechte legt diese Rechte einseitig zugunsten illegaler Migranten aus und beraubt die nationalen Parlamente ihres notwendigen Handlungsspielraums. Laut Entscheidungen des Gerichtshofs dürfen kriminelle Migranten oft nicht abgeschoben und auch unsere Grenzen nicht wirksam geschützt werden. Wer solche Entscheidungen trifft, missachtet die Rechte der Menschen, die schon länger hier leben. Auch wir Deutschen, auch die Ungarn, auch die Italiener, auch alle Europäer sind Inhaber von Menschenrechten. Und auch wir haben eine Menschenwürde. Und auch wir haben ein Recht darauf, in unserer eigenen Heimat sicher und körperlich unversehrt zu leben. Genau dieses Recht wird jedoch durch illegale Migration immer stärker herausgefordert und in Frage gestellt. Wer diese Realität missachtet, der betreibt keine Rechtsprechung, sondern linken politischen Aktivismus von der Richterbank aus. Einige mutige europäische Regierungschefs haben dies in einem offenen Brief klar benannt. Sie fordern völlig zu Recht, dass Sicherheit und Schutz der europäischen Bürger endlich wieder Vorrang haben müssen. Dieser Brief bestätigt exakt die Position der Alternative für Deutschland, die wir seit Jahren vertreten. Ich fordere deshalb alle europäischen Regierungschefs auf, sich diesem Brief anzuschließen, allen voran den deutschen Bundeskanzler. Und ich frage Herrn Merz, was hält Sie denn eigentlich noch ab, diesen Brief mitzuunterzeichnen? Lassen Sie Ihren Worten im Wahlkampf endlich Taten fordern und machen Sie nicht nur Deutschland, sondern ganz Europa friedlicher, sicherer und gerechter. Vielen Dank.
Thank you. Aurora Florida is next. Aurora.
Thank you, Mr. President, dear colleagues. Oggi scelgo di intervenire in italiano. Intendo infatti rivolgermi anche al mio paese, l'Italia, perché è soprattutto in casa nostra che si sta alimentando un clima preoccupante di messa in discussione dei fondamenti della democrazia. Oggi avverto l'onere di sollevare la questione di un'offensiva politica ben precisa, una rete coordinata promossa dai partiti di estrema destra che attraversa i confini e che oggi punta alla Convenzione EDU. Una rete che sotto il pretesto di aggiornare la Convenzione mira in realtà a svuotarla di significato, come sta già avvenendo peraltro anche in Italia con alcune libertà fondamentali, a cominciare da quella di riunione. È pericoloso, e lo dico con massima chiarezza, strumentalizzare temi così delicati con operazioni mediatiche travestite da lettere aperte. Non sono semplici opinioni, sono atti politici che mettono in discussione la legittimità di una Corte indipendente. Il rischio è evidente: manipolare l'opinione pubblica, delegittimare il potere giudiziario, smantellare gradualmente diritti fondamentali che mettono in pericolo la stabilità democratica. Basta guardare infatti quante volte la Convenzione EDU è già stata aggiornata per capire che questa nuova urgenza non è tecnica, ma profondamente politica. Purtroppo non credo alla buona fede di chi chiede la revisione di trattati e istituzioni senza un previo confronto tecnico e parlamentare. È un metodo opaco, sintomatico di una visione del potere verticale, impermeabile alla verifica democratica. Colleghe e colleghi, difendere le istituzioni europee significa difendere noi stessi, perché oggi la democrazia è come un fuoco acceso in una notte ventosa. Va protetta con cura e alimentata con costanza per non spegnerla. Quindi niente distrazioni e ingenuità, ma occhi aperti, dobbiamo vigilare sulla democrazia. Grazie.
Grazie, Aurora. Thank you. Baroness Hamid Chakrabarti is next.
Mr. President, colleagues, our Convention on Human Rights and its Strasbourg Court constitute the most successful rights protection mechanism in human history. Their values, having been distilled by a post-war generation well used to times as challenging and dangerous as our own, are well capable of helping us navigate the challenges and dangers of our own century without ignoring the hard lessons of the last one. To the question of whether we might build on existing rights, I say, of course we might. Whilst, for example, rapid developments on the internet and in artificial intelligence engage and violate rights against degrading treatment, to fair trials and private life, for freedom of expression and against discrimination, they might also inspire new rights to access these technologies and to transparent decision-making, or new protocols designed to make the traditional rights more effective in this new online continent. We might, of course, think about making universal human rights more directly, practically enforceable against global corporations. But today's debate seems more about the challenge from those, even perhaps amongst us, who seek to diminish convention rights, not enhance them. They want to clip the wings of the court and refuse rights to non-citizens. They should perhaps remember that we are all foreigners almost everywhere, including in other member states. And there is no such thing as democracy without the rule of law.
Thank you, Sami. Susan Fürst.
Sehr geehrter Herr Präsident, sehr geehrte Damen und Herren! Der Europäische Gerichtshof für Menschenrechte ist vom rechten Weg, vom Weg des Rechts abgekommen. Historisch hat er die vornehme Aufgabe, die Europäische Menschenrechtskonvention zu verteidigen und auszulegen. Gemäß seiner Bestimmung hat er sich in seiner Rechtsprechung zurückhaltend zu verhalten und die nationale Gesetzgebungskompetenz der Mitgliedstaaten zu respektieren. Doch diesen Weg verließ der Gerichtshof vor längerer Zeit. Nur zwei Beispiele. Erstens, statt Recht zu sprechen, agiert er als Aktivist aggressiver Asyl- und Einwanderungspolitik nach Europa. Der Gerichtshof untersagt in seiner Judikatur Mitgliedstaaten die Abschiebung selbst schwerstkrimineller, Mörder oder Kinderschänder, weil es der Konvention widersprechen würde. Das ist unfassbar, eine totale Fehlinterpretation der Konvention. Zweitens, statt Recht zu sprechen, agiert der Gerichtshof als Aktivist irrationaler Klimapolitik. Er gab einer Klage von zwei Schweizerinnen Recht, welche von ihrem Land stärkere Anstrengungen in Sachen Klimaschutz verlangten. Ihre Gesundheit sei gefährdet durch stärkere Hitzewellen. Sie bekamen Recht, das ist unfassbar, ein Eingriff in die nationale Kompetenz der Schweiz und in die direkte Demokratie, denn die Bevölkerung in der Schweiz hat genau das mehrheitlich abgelehnt. Nun zum offenen Brief von mehreren Regierungschefs betreffend der Neuauslegung der Konvention und dem Verlangen nach mehr nationalen Spielraum. Dieser ist völlig berechtigt, aber bei weitem nicht ausreichend. Wir müssen uns entschiedenst gegen die Übergriffe und die Ambitionen des Gerichtshofs in Straßburg stellen, Politik zu machen. Dafür ist er nicht zuständig. Er ist zuständig für die Interpretation der Menschenrechtskonvention und Judikatur im Sinne der europäischen Bevölkerung. Vielen Dank.
Thank you, Susan. Bizera Konstantinos-Kastojevska is next. Bizera.
Thank you, Mr. President. The European Convention on Human Rights is a supranational convention to protect human rights and political freedoms of Europe. The European Court of Human Rights makes sure that they are indeed protected. According to Raimondi, the European system of protection of human rights with its court is inconceivable untied from democracy. In fact, we have a bomb that is not only regional or geographic. A state cannot be party to the European Convention on Human Rights if it's not a member of the Council of Europe. It cannot be a member state of the Council of Europe if it does not respect pluralist democracy, the rule of law and human rights. So a non-democratic state should not participate in the European conventional human rights system. The protection of democracy goes hand in hand with the protection of rights. While we have been struggling to stay off the track that goes straight into World War III, now that for almost 2 years we have seen the atrocities all around the world that are beyond imaginable, that we work on establishing separate judiciary instances for the atrocities in Ukraine, 75 years after the establishment of these two instruments that cement deeply into our nations the protection of human rights, both the European Convention of Human Rights and the European Court of Human Rights need not be questioned or debated, but need to be looked after and implemented. We need to debate the misplaced children, the prisoners of war, the humanitarian aid collapse, the ceasefire, erosion of human rights, demotion of rights of women, demotion of rights of LGBT community. Let's focus on that.
Thank you, Bissera. Gergely Arato is next.
Dear Parliamentary Assembly, when Europe woke up 80 years ago from the horror of the Second World War and the Holocaust, it became clear that there is only one solution to end dehumanization, exclusion, and murder: to set up clear human rights standards and enforce it. We are all politicians. We serve our constituents and our country's need in the best way we see. And I clearly understand how frustrating if some of the policies are blocked by the EHCR. Yes, it's clear. It's a problem. And sometimes the voters themselves does not understand why the policy which was promised them and they think is right cannot be achieved. Yes, there are limitations and obstacles, but I think they are necessary to defend our freedom and humanity. Sometimes it's easier to deny the decisions and attack the court, but I think the work we should do to find better solution, the thinking, the arguing, is something that benefits to our people and benefit to our countries. If human rights can be denied to one, then it can be denied to anyone. If today the human rights of the refugees is not important, today there will be the right of the LGBTQ community or national minorities, and day after tomorrow there will be the right of the woman or anybody else. Believe me, I am from Hungary, I know it. So no matter how popular to attack the court, human rights, and the rule of law, in the long run, that will lead a weakening of the democracy, legal certainty, and humanity that I am sure not
Thank you, Gergely.
of any of us to want.
Thank you.
Thank you.
Tony Vaughan is next.
Thank you, Mr. President. We all recognise the real and pressing challenges our nations face. But in my view, the case for rewriting the European Convention itself is not at all clear. First, national governments already have plenty of scope to act within the Convention as it stands. Take the UK. The UK Parliament has already been tightening up how Article 8, the right to family life, applies to foreign offender deportations for several years. The UK has legislated to define when the public interest outweighs family ties, and the Labour government will do more on this. So there is no need to tear up the rulebook to keep our streets safe. Second, on Article 3 and torture, yes, there are challenges, but the answer is more international cooperation, not less. National governments already work with other countries to tackle concerns such as about prison conditions and medical cases, and we should build on cooperation like this within the terms of the existing convention. But let's also face facts. The so-called case for reform is often based on myths and misinformation. In the UK, we all heard a story about an Albanian national who defeated, supposedly, deportation because his child wouldn't eat Albanian chicken nuggets. Now, this was utter nonsense, yet it spread like wildfire, it stoked outrage and gave cover to those in the UK who would want us out of the convention altogether. we have a duty to call out these falsehoods and stand up for the truth. Finally, we must not open a Pandora's box. If we start unpicking the Convention's core protections, we risk unravelling not just the ECHR, but the foundations of democracy and the UN system and the international legal order itself. So when we have that debate about amending the ECHR, we must scrutinise the case for change very carefully, because there is much we can already do. So let's work together to improve how we apply the Convention and not undermine its bedrock values. Thank you.
Thank you, Tony. Paul Zablonski.
Thank you, President. Dear colleagues, I'm hearing this discussion, especially from the left side, and I see that many of you are outraged by the simple fact that 9 leaders of the governments decided to speak in a very polite and adequate manner that they do not like certain aspects of legal reality that we are facing, certain aspects of judicial activism that we see on the part of European Court of Human Rights. Now, I understand that some of you may not agree with the content of the letter, but the fact that the prime ministers, democratically elected leaders from many political groups decided to express themselves is nothing that should be condemned. But when I hear you, you seem to act as some sacred taboo was infringed by the mere fact that these prime ministers and leaders decided to speak. Dear colleagues, here we are in the Parliamentary Assembly, Parliament. On y parle. We talk here, we debate, and if we don't like some elements of the law or its application, we discuss it. It's not an attack on the rule of law. An open letter being an attack on the rule of law. If this would be an attack on the rule of law, then the rule of law in itself would seem to be very, very weak. Rule of law is much stronger than that, and open letters are not attacking it. Open letters are initiating a process of a debate. Here we are in this. And we speak of human rights. Dear colleagues, our citizens, our women and children and men also have human rights to have safe streets, to be protected, to have secure borders. Well, let's safeguard these rights. If we are so bold in speaking whom we should protect, let's start at home. Let's protect our people.
Thank you, Paul. Sandra Zamba is next. Sandra.
Grazie Presidente. Per evitare una debacle elettorale, l'ex primo ministro conservatore del Regno Unito, Sunak, si era aggrappato alla questione migratoria e aveva messo in discussione la Corte europea dei diritti, che gli aveva impedito di attuare il suo piano di espulsione. Sappiamo come è andata a finire. Oggi torna quello spirito nella lettera pubblicata dai 9 paesi, rivolta evidentemente all'opinione pubblica, per attaccare la Corte accusandola in qualche modo di impedire l'esercizio della loro autorità e del loro potere. Si tratta a tutti gli effetti di una messa in causa dei diritti umani e di un attacco alla separazione dei poteri. Non si può suggerire, come fa la lettera, che ci siano diritti umani di serie A e di serie B, o che i diritti fondamentali siano una concessione ai meritevoli. I diritti fondamentali non sono concessioni discrezionali, bensì garanzie imprescindibili da rispettare per ogni individuo, indipendentemente, così come la separazione dei poteri è la salvaguardia, e tale deve restare, salvaguardia essenziale per la sopravvivenza della democrazia. Voglio concludere citando quanto il segretario generale Berset ha detto appena letto questa lettera. In una società governata dallo Stato di diritto, nessun organo giudiziario dovrebbe subire pressioni politiche. Le istituzioni che proteggono i diritti fondamentali non possono piegarsi ai cicli politici. E credo che faremmo tutti molto bene a ricordarcelo, perché i cicli politici cambiano, ma i diritti fondamentali dell'uomo non devono e non possono essere sottoposti a questo cambiamento.
Thank you, Sandra. Mogens Jensen is next. Mogens.
Thank you, Mr. President. Dear colleagues, the European Convention on Human Rights and the European Court of Human Rights are fundamental and cornerstone pillars of European cooperation. This has been the case since the end of the Second World War, and it must remain so in the future. It is necessary, it is important. However, to ensure that this continues, it is crucial that both the Convention and the Court's work and judgments are respected by the populations these institutions are meant to protect. There must not arise a large gap between the Convention and the Court's decisions and the reality experienced by ordinary citizens. Therefore, we must be able to continuously discuss, among other things, the Court's interpretation of the Convention. It is not, and it should not be set in stone, as it has many years on its back. This discussion we also have taken over the years as well. In the last 15 years, there's been specific discussions about the Court's work and premises in Interlaken, in Brighton and Copenhagen, where we have made declarations, where we emphasize the need and possibility for dialogue on the Court's work. And this letter from 9 member states should be seen in that context, not as a confrontation with either the Convention or the Court, but as a desire to ensure the support for these fundamental pillars is also firmly grounded in the future. It's no use for us as a parliament or organization to put ourselves in a corner and close our ears, eyes and mouth, refusing to discuss the challenges of reality. Therefore, I also find it very positive that the Secretary General is now proposing to find the right ways to engage in this dialogue and ensure cohesion and respect between the Convention, the Court, governments and people. Thank you very much.
Thank you, Mogens. Céline Thibault-Martinez is next.
Merci, Monsieur le Président. Monsieur le Président, mes chers collègues, je voudrais profiter de ce débat pour rappeler à quoi sert la Cour, à quoi elle sert concrètement pour chacun d'entre nous. Je voudrais vous parler de Julie, une adolescente française qui accusait 22 pompiers de l'avoir violée entre 2008 et 2010. Julie était alors âgée de 13 à 15 ans et se trouvait en situation de grande détresse psychologique. Elle a fait plusieurs tentatives de suicide, ce qui l'avait laissée lourdement handicapée. Au bout de 10 ans de procès, seuls 3 pompiers sur les 22 accusés étaient poursuivis, non pas pour viol, mais pour atteinte sexuelle. En 2020, c'est la plus haute juridiction française qui a confirmé la requalification des faits, parce qu'elle a considéré que Julie, malgré son état, était consentante. Finalement, la Cour européenne des droits de l'homme est venue rétablir l'honneur de Julie et l'honneur de la justice française. Dans une décision de 2025, la France a été condamnée pour son manque de rapidité à juger une telle affaire. Condamnée aussi pour son incapacité à proposer un système pénal apte à sanctionner des faits non consentis et subis par des mineurs. Cet exemple montre que la Cour européenne des droits de l'homme est un garde-fou, une protection pour tous les citoyens et les citoyennes quand nos systèmes judiciaires ne mesurent pas suffisamment la gravité des faits tels que les violences perpétrées à l'encontre des femmes et des filles. Nos États, nos démocraties peuvent parfois oublier leurs principes, négliger leurs valeurs. La Cour est là pour appeler les lois, nos lois, garantir l'équité devant la justice. Elle est un outil démocratique. Elle est la preuve de la vitalité de nos États de droit. Remettre en cause son rôle au nom d'une obsession migratoire, contester ses décisions alors que nous sommes les artisans de cette juridiction, c'est renoncer à l'exercice de nos libertés et de nos droits. C'est laisser la place à l'arbitraire. C'est faire un bond en arrière dans l'histoire de la démocratie et de la justice. Je vous remercie.
Thank you, Céline. And the last in my list is Lord Don Twigg.
Mr. President, across Europe, we are seeing more and more challenges to human rights, democracy and the rule of law. Our convention is essential to defending these rights. As British and European, I'm proud of the fact that the United Kingdom played a major role in establishing the Council of Europe and drafting the Convention. For my part, I was very pleased that last week the Lord Chancellor of Great Britain, addressing the Committee of Ministers here, reaffirmed Britain's continued support for the Convention and told the President of the Court that it had her full support in interpreting and applying the Convention. But that does not mean we should not have discussions about the Convention. It has endured because it has evolved over time. Now, I personally do not think the letter signed by the 9 is the way forward. But burying our heads in the sand when faced with the questions that the letter raised will solve nothing. We should not be afraid to have this discussion about the Convention. And I welcome the words you uttered yesterday, Mr. President, when you spoke. And I also welcome the comments of the Secretary-General, who, in responding to the letter, emphasised the need for dialogue and open discussion on the Convention, while also cautioning against politicising the European Court of Human Rights. I end by reading a sentence from the Lord Chancellor's speech to the Committee of Ministers. She said this: "When people come to believe that rights only exist to protect the rule breaker, not the rule follower, those who would undermine the entire idea of universal human rights, the populists, and we've got plenty of them, they will seize the space that we leave behind. Colleagues, our Convention is too precious, essential to defending our freedoms. We must not let the intolerant and the bigoted undermine and destroy it."
Thank you, Don. Dear colleagues, I will give now the floor to Lord Keane to respond. Dear Richard, you have 3 minutes.
Thank you, Mr. President. Colleagues, what is apparent, I believe, taking a cross-section of the views expressed here, is the need for us as the Assembly and a need for the Committee of Ministers to ensure that the terms of the Convention and its protocols reflect not only the fundamental rights and freedoms that they are intended to encompass, but also the democratic desires and the democratic aims of the state parties to the Convention. I welcome the open letter that I didn't receive, not because I believe it was an appropriate mechanism to raise questions with regard to the Convention and the Court, but because it has stimulated a debate that we require to have. But that debate will take place in the political sphere, not in the judicial sphere. And I consider it inappropriate to draw the Court in to such a political debate. As I mentioned at the outset, we should respect the separation of powers, and we should respect the role of the Court, which is intended to ensure that the political parties, the state parties to the Convention, actually temper their obligations and discharge the rights that the Convention has granted. It does no more than that. It does no less than that. It should do no more than that. And where there is a fear of judicial activism, then we can speak out, and no doubt the Court will listen. But at the end of the day, the separation of powers do matter, and the Court rests entirely upon state consent. I thank everyone for their contributions.
Thank you, Lord Keane. Dear colleagues, you have heard my opinion yesterday. I shouldn't intervene, of course, in this debate. I only want to share with you an information received by a friend, a lawyer who's watching us from Athens, about the adaptivity of the rule in modern times. And I'm sure that Richard will agree with that. The oldest law still in force today in the world is the Statutes of Marlborough, enacted in 1267, 800 years ago, as part of English parliamentary law. It is not a message. It is not a message. I'm really glad that I had participated in presiding this tremendously, in my opinion, interesting discussion we had today. An interesting exchange of views. I want to thank all of you, all political groups, all my colleagues that took the floor. I want, of course, to thank the President of the Court for his participation. Mr. President, I believe that judges should listen to the voice of society and then, of course, take the decisions by the voice of the law. But the society and the law are connected. This is very difficult. It was very easy for us to express our opinions. Now the difficult part is yours. I'm really glad that you have said that you are available to this institution and to this assembly, and you are always welcomed here. Thank you all, dear colleagues, and thank you, Sir Lord Keane, for your remarks. Now, I remind you that we come now to the joint debate on two reports from the Committee on Legal Affairs and Human Rights and the Committee on Political Affairs and Democracy, respectively. The first is titled Legal and Human Rights Aspects of the Russian Federation's Aggression Against Ukraine, presented by Mr. Eric Neil Cross on behalf of the Committee on Legal Affairs and Human Rights and the Committee. The second is titled Support for Political Negotiations to Enforce Exchange and Release of Prisoners of War, presented by Elizaveta Iasko as rapporteur and Rian Vogels as rapporteur for opinion on behalf of the Committee on Political Affairs and Democracy. Yes, I just want to remind you that there is a vote on a judge. The ballot place is behind the presidency desk. You can vote until what time, Despina?
1 o'clock.
1 o'clock. So we will finish with the debate that is about to start at 12 p.m. in 25 minutes, but the debate will be continued in the afternoon. I remind members that speaking time is in this debate limited to 2 minutes. I call now Mr. Eric Niels Cross, rapporteur, to present the first report for the Committee on Legal Affairs and Human Rights. Dear Eric, you know that you have 7 minutes now and 3 minutes at the end to reply to the debate.
Dear President, dear colleagues, it is really an honor to present to you today this draft resolution on the legal and human rights aspects of the Russian Federation's aggression against Ukraine. We all have an obligation to defend the principles and values on which the international order stands and upon which European freedom rests. We all have an obligation to defend Ukraine, and this is how we do our part. The draft resolution before you today is the third in the, so to say, series of those reports, and it could not come at a more important time. On one hand, it comes as Russia's war of aggression against Ukraine, Russia's crimes against peace intensify. These days, we are witnessing some of the deadliest attacks since the full-scale invasion began in February 2022. More than 3 years into the Russia's full-scale war against Ukraine, we must speak plainly. The aggressor is systematically violating the rights of Ukrainians all over the Ukrainian territory. The report before you documents an array of grave breaches. Murder, strikes against civilians and civilian infrastructure, against schools, hospitals, kindergarten, museums, theaters, and churches. Arbitrary detentions, torture, illegal mass deportations, property confiscation, suppression of identity. And these are not isolated events. These are features of a deliberate policy. Yesterday, when we were debating other topics here, Russia launched 352 drones and 16 missiles against Ukraine. Russian troops attacked a group of teenagers playing volleyball with a Lancet drone in Novi Borochi, Chernigov region. They also hit a school in Odessa region, killing and injuring multiple people, and also yesterday in Kiev, an entire section of a residential building was destroyed, and at least 9 people were killed, 35 were injured. Now, all these strikes constitute war crimes. And the Prosecutor General's Office of Ukraine has registered more than 160,000 war crimes committed against Ukraine since 2014. The Assembly, again in this resolution, reaffirms that many of these crimes, including forcible deportations, targeted attacks on civilians, torture, etc., amount to war crimes, crimes against humanity and possibly genocide. These are crimes that under international law cannot be subject to amnesty or statute of limitations. On the other hand, this resolution arrives on a day when we are finally about to create the special tribunal for the crime of aggression against Ukraine. Tomorrow, President Zelensky will visit us to sign on behalf of Ukraine the legal documents needed to launch the special tribunal. He will hopefully also address this assembly. In this context, I want to highlight the role of the Parliamentary Assembly has played in making this special tribunal a reality. The Assembly was the first to propose the establishment of the tribunal to investigate and prosecute the crime of aggression committed by Russia's political and military leadership back in 2022. At that time, many found this idea unrealistic and even laughable. That proposal is now approaching realization. We welcome the work underway toward its establishment and call on all member states to support its full and independent functioning. The world must know that aggression will be punished. The draft resolution I present today builds on the foundations of previous resolutions and reflects recent developments, such as the progress on the tribunal, hearings held by the Committee in Legal Affairs and Human Rights, Legal Affairs and Human Rights Committee, and also my fact-finding missions to Kiev and Ukraine in early April and in June. The draft resolution also affirms that the tribunal is indeed a vital but only one part of a comprehensive accountability system for Ukraine and for the international legal order. A lot of work is yet to be done. The draft resolution also urges all member states and international partners to increase their support for Ukrainian prosecutors and existing international accountability mechanisms, as well as civil society projects working on Ukraine, especially to fill the gap left by the recent US decision to withdraw from some of the projects and suspend aid. I would like to especially mention here all the efforts to return the Ukrainian children from Russian captivity. The resolution reiterates 15 undisputed legal and human rights principles that must be respected by all members and observer states, as well by all European institutions and international partners during any future peace talks or negotiations. For example, the resolution says the principle that crimes committed by Russia and its leaders in Ukraine cannot be subject to any form of amnesty under international law. It also emphasizes that according to international democratic standards, elections cannot be held under martial law, and that President Zelensky remains the legitimate president of Ukraine until elections can lawfully be held. Perhaps most importantly, it emphasizes that illegal annexation of any Ukrainian territory since 2014 is a breach of Jus Cogens norms and cannot be recognized under any circumstances. Any attempt to coerce Ukraine into recognizing these annexations would itself violate international law. Finally, the draft resolution also refers to the situation of POWs, unlawfully detained Ukrainian civilians, and most importantly, deported and illegally transferred Ukrainian children. It is essential that the issue of the exchange of POWs and the release of children remains central to any peace process. Even today, when we speak here, children are taken from their families, forcibly relocated to Russia or Russian-occupied Crimea, placed in camps, or adopted under false identities. These acts are not only violations of international law, they are war crimes and crimes against humanity. Russia is obliged under international law to provide complete information concerning POWs, civilians, and children under its control. and comply with its most basic obligations under international humanitarian law. If this doesn't happen, we need to increase pressure on Russia with more sanctions.
Thank you, Eric.
I ask you to support this resolution and let it remind the world that Europe remembers what justice requires and that never again is not empty words.
Thank you. I call now Elisaveta Iasko, Rapporteur, and Rian Vogels, Rapporteur for Opinion, to present the second report from the Committee on Political Affairs. Elisaveta, you have 7 minutes now and 3 minutes at the end to reply to the debate.
Thank you, President. Dear colleagues, today once again we're discussing Russian crimes against Ukraine. Unfortunately, it continues, but it's great that in this assembly we discuss political aspects and the legal aspects together. I've been a member of this assembly 6 years already, but I think only in the recent weeks I became very, very scared of what happens in the world so much. Before coming here, I faced 2 big attacks in Kiev with a lot of massive drones and ballistic missiles flying over my window and doors. This is what we face every day, but it was the first time when I felt that things are getting so much worse. We often feel powerless because it seems that this war has changed all international order, all laws, regulations sometimes don't matter anymore. But in fact, there are areas when we do have a power to make a change. When I feel very often powerless and hopeless, recently the situation of the prisoners of war and recent prisoner swaps and exchanges that we had actually gives me a hope. We do have a power to facilitate the exchanges and to reach some next steps for possible negotiations for peace. Despite all regulations that Geneva Convention has on the prisoners of war, Russia doesn't comply with that rules. And for us, the only fulfillment for us, Ukraine, that Russia actually agreed to fulfill recently was to arrange these exchanges. And recently in Istanbul, with attempt to establish these peace negotiations, luckily we managed to get more than 1,000 our servicemen back. And let me tell you more about the shape and the situation of the prisoners of war and what they are facing. Various international monitoring mechanisms, such as UN, Independent International Commission, and ICRC and Human Rights Monitoring Mission of United Nations, had verified that there are many violations that include ill treatment, widespread and systematic torture, summary executions that are regular and often filmed on camera. There are verification of execution of 71 Ukrainian prisoners of war and recorded the deaths of at least 21 prisoners of war in custody. While the real figures are much higher, we cannot have the exact number, but we know that there are hundreds of these cases. Ukrainian prisoners of war are denied access to adequate nutrition, medical attention, legal advice. They are not held in appropriate places of detention. They are subject of verbal, psychological, physical, sexual abuse. They are not permitted to communicate with their families for weeks, months, and even years. And unfortunately, the current tracing system that should identify all detention centers of these people, that is governed and organized by ICRC. Unfortunately, ICRC is not capable to identify all these places because Russia doesn't allow them to do so. International Committee of the Red Cross is not permitted to fulfill entirely its mandate to provide the medical care and to appoint a mixed medical commission to examine sick and wounded prisoners of war, because Russian Federation has so far rejected initiatives and also initiatives by other states to assume the role of protecting powers. So all the regulations that we have on that, Russia is denying. Unfortunately, these systematic tortures in various detention facilities suggest that there is a huge endorsement by the Russian civil and military authorities at the highest level. Dear colleagues, you do have the power to put an end to this and to do everything to facilitate the repatriation of the Ukrainian prisoners of war. I want to emphasize that you do have this political power because we are very grateful to every member state that maybe doesn't have a mandate to do so, but is being creative and is acting as a mediator to help us to return as many people as possible. And I want to express the gratitude to Turkey and to United Arab Emirates to help us with the prisoners of war. Please, let's use this creative governance and mediation possibilities to bring more people home. And let's do everything possible to insist on strengthening the tracing, identification system and medical care capabilities of ICRC, and more importantly, on insisting that Russian authorities will accept what is already available in the regulations. You do have the power to support the prisoners on their return home by providing more political, financial, material, and technical support for establishment of such mechanism. Consider the identification of a neutral country where prisoners of war could be safely returned home later. Finally, I would like to emphasize that this resolution highlights the importance of accountability, and by calling all states to support the work of International Criminal Court, Tribunal, and make sure that we use the instrument of universal jurisdiction to prosecute Russian officials involved in war crimes and other crimes. These decisions are needed not only for Ukrainian prisoners of war, but to every prisoner of war of the future and who is currently suffering from many, many violations. We need to amend this international system of humanitarian law and provide more capabilities to protect prisoners of war. Doesn't matter where they come from. Thank you.
Thank you, Lisa. Rian Vogels. Rian, you have 3 minutes.
Thank you, President. Dear colleagues, allow me first to congratulate Ms. Jasko on an excellent report that thoroughly addresses a very delicate issue. My task as rapporteur for the opinion appointed by the Committee of Legal Affairs was indeed difficult. After all, how can one think of legal arguments when dealing with a state, a permanent member of the United Nations Security Council, that has shown and continues to show blatant disregard for the most fundamental principles of international humanitarian law? In his 1986 Nobel Prize lecture, Elie Wiesel famously said, and I quote, "There may be times when we are powerless to prevent injustice, but there must never be a time when we fail to protest," unquote. And so today, just like so many times before, we reiterate our attachment to inalienable human dignity and our unwavering commitment to uphold the rule of law. The 3 amendments I proposed in the opinion are technical in nature and aimed at increasing the accuracy of the draft resolution. The opinion takes stock of the existing information collected within the framework of the OSCE Moscow mechanism regarding the dysfunctional operation of the Russian National Information Bureau. It also clarifies the scope of the Third Geneva Convention with regard to the obligation to release and repatriate prisoners of war, which becomes applicable only after the cessation of active hostilities. Nevertheless, accelerating the release of Ukrainian prisoners of war must be a priority, especially considering the inhuman conditions of their detention. In sum, this resolution stands as a powerful reminder that, even in the darkest times, our commitment to uphold human dignity must shine through. I hope we can be united on this shared mission. Thank you.
Thank you, Rian. I open now the list of the speakers on behalf of the political groups, calling first Markus Wissel on behalf of the European Conservatives, Patriots and Affiliates. Markus.
Esteemed colleagues, today we stand resolute in our unwavering support for Ukraine and our Ukrainian brothers and sisters. We find ourselves at a critical moment, one that will not only shape the future of Ukraine, but it will also test the very principles that reinforce the core values of this Assembly, international law, and our collective humanity. We have witnessed atrocious acts such as indiscriminate attacks on civilians, torture and execution of prisoners of war, unlawful detentions and the forced deportation of Ukrainian children, among many others. These are not merely legal infractions. They are crimes against humanity that demand unwavering accountability. The establishment of a special tribunal for the crime of aggression against Ukraine is not a mere aspiration. It is an absolute necessity. All our member states must expedite the creation of this tribunal so that justice can be served. The Russian Federation, along with any other state or actor complicit in this aggression, be it Belarus, North Korea, or Iran, must be held accountable for their crimes. Furthermore, we must prioritize comprehensive reparations for Ukraine. The Register of Damage for Ukraine and the forthcoming Claims Commission are crucial steps towards addressing the profound suffering endured by the Ukrainian people. Let us champion mechanisms that will ensure reparative justice and call for the redirection of frozen Russian assets to support this cause. In conclusion, any progress in peace negotiations must include the unconditional release of prisoners of war and unlawfully detained civilians. The safe return of deported children must be a cornerstone of our peace efforts, ensuring their reintegration into Ukrainian society and reunion with their families. We stand with Ukraine not only because history and justice demands it, but because our shared humanity commands it. Together we will demonstrate to the world that aggression will not go unchallenged, and we will secure both peace and justice for Ukraine.
Thank you, Markus. Stefan Gettings on behalf of ALDE.
Thank you, Mr. Chairman, can I first of all commend my colleagues Ms Jasko and Mr Kroes for their powerful testimony, but also for their hard work and their insights around Russia's war and aggression and the release of prisoners. Mr Chair, this is my first time speaking in this chamber, and I can think of no more appropriate issue to be my opening speech than on this one. Ukraine and Russia's war is a defining issue for us as Europeans, and how we react and continue to react will be pivotal for our common future. It goes to the fundamentals of why we gather here as Europeans and the common values and rights that we need to protect that solidarity, and that solidarity must mean something. If our rights are not respected in one part of Europe, they cannot be universal rights. If one citizen is affected, so too are we all affected. That's why we must react to Russia's crimes against our fellow citizens, and their inhumanity must be important to us all. And I've listened to the reality from our Ukrainian colleagues in this chamber and elsewhere when they speak to us. We talk about the impact on us all, including prisoners, combatants, and also non-combatants, including children. Children ripped away from their families. Russia has breached the convention, but also the international norms as well, and must be held accountable. Russia deliberately targets civilians and first responders. Russia abuses its prisoners. So for the rules-based system to mean anything, we must look at everybody without fear or favour, so I commend my colleagues for also looking at Ukraine. But Ukraine provides unfettered access to international organisations, as Ms Jasko rightly pointed out. For these crimes, there must be accountability. And I commend Mr Kroes on the recommendation for an international tribunal. That is pivotal for accountability. Sovereignty pooled is sovereignty enhanced. So I back these reports and I thank our colleagues and we back Ukraine. Thank you, Mr Chair.
Thank you, Stefan. Sofia Sekiron on behalf of the United European Left.
Thank you, Mr. President. Merci, Monsieur le Président. Nous condamnons tous fermement l'agression brutale de Vladimir Poutine contre l'Ukraine. Nous exigeons ensemble le retour immédiat des milliers d'enfants ukrainiens déportés et la justice pour les crimes de guerre et crimes contre l'humanité perpétrés. Mais attention, un tribunal spécial ne sera jamais l'alpha et l'oméga d'une paix véritablement durable. Or, ces résolutions passent complètement sous silence la résistance intérieure en Russie. Actuellement, plus de 3000 prisonniers politiques russes sont détenus pour avoir osé s'opposer à cette guerre. Nous avons entendu ici même les témoignages poignants d'Evgeny Stupin, de Mikhail Lobanov, d'Alexis Sakhnine ou encore Alexander Bykov qui rappellent que 50 000 Russes ont déserté pour ne pas participer à cette agression criminelle. Ces hommes et ces femmes mettent leur vie en péril chaque jour. Ils sont harcelés, torturés, emprisonnés comme Boris Kagarlitsky, Alexei Gorinov ou Azat Mishtakov, doublement condamnés pour ses positions anti-guerre. Ne les abandonnons pas. Soutenir les prisonniers politiques russes est un acte politique essentiel pour construire des ponts. De même, je souhaite attirer votre attention et dénoncer les conséquences de la loi martiale en Ukraine et les abus du recours à l'article 111.1 et notre devoir à nous de veiller à ce que les militants politiques et syndicalistes objecteurs de conscience ne soient pas accusés de collaboration au mépris du droit international, comme l'a souligné la Cour européenne des droits de l'homme et la Commission de l'ONU contre la torture. Si nous voulons être fidèles à nos principes qui sont le droit international, les droits fondamentaux, la justice internationale, nous devons condamner fermement le régime criminel de Poutine, nous devons soutenir la résistance intérieure russe et les initiatives citoyennes comme People First, mais nous devons aussi préparer les conditions d'une paix juste, fondée sur une amnistie générale, le droit au retour des réfugiés politiques. Nous devons exiger le plein respect des libertés fondamentales en Russie, mais aussi en Ukraine, qui doit se mettre en conformité avec ses engagements internationaux et la Convention des droits de l'homme.
Thank you, Sophia. The Minister has arrived, as you see, but Minister, I will give you 2 minutes to get prepared. I'll give the floor to Marietta Karamanli. Kalimera, Marietta, you have the floor.
Merci, Monsieur le Président. Kalimera. Tout d'abord, au nom de mon groupe, je souhaite tout d'abord remercier nos deux rapporteurs, M. Kroes et Mme Jasko, pour les deux rapports. Tous deux soulignent sur deux sujets connexes la nécessité justement de rendre justice à l'Ukraine à un moment où la situation internationale est particulièrement instable et incertaine et où nous pouvons perdre de vue la guerre qui menace aux portes et sur le continent européen. Concernant les questions de droit et des violations des droits de l'homme en lien avec l'agression russe, il convient de réaffirmer les principes fondamentaux du droit international selon lesquels la responsabilité pénale individuelle des dirigeants politiques et militaires de la Fédération russe peut être et sera engagée. Une juridiction internationale créée pourra connaître du crime d'agression. La réparation des dommages causés à l'État ukrainien et ses citoyens devra être assurée par une commission de demande d'indemnisation. Toute solution diplomatique et politique encore à venir doit prendre en compte le droit à l'intégrité de l'État ukrainien et de son peuple. Et s'agissant de la libération des prisonniers de guerre, des députés socialistes souscrivent aux différents points du projet de rapport. Nous soutiennent notamment la mise en œuvre, je cite, d'un mécanisme structuré et permanent, négocié et accepté par toutes les parties intéressées, et ce qui doit éventuellement être coordonné par la CIR pour permettre de façon rapide, sûre et régulière l'identification, la recherche, la libération et l'échange de tous les prisonniers de guerre, en accordant une attention particulière à ceux qui sont gravement blessés ou malades. Tous les pays adhèrent à la 3e Convention de Genève, Genève, laquelle octroie également un mandat spécial au CICR et un rôle central dans la protection de la dignité et du bien-être des prisonniers de guerre. Le groupe des députés socialistes, démocrates et verts soutient ces démarches et est favorable au principe des évolutions ainsi portées, rappeler au gouvernement de la Russie et à la communauté internationale au respect du droit international et encourager une action active pour assurer un traitement décent de l'État et de ses citoyens et du respect de leurs droits. Nous voterons tous les deux rapports. Merci.
Thank you, Marietta. Dear colleagues, we will close now this debate, which will continue this afternoon after the Q&A with Secretary General Berset. Ladies and gentlemen, dear colleagues, it is an honor for us now to welcome to this assembly Mr. Ian Borg, Deputy Prime Minister and Minister of Foreign Affairs and Tourism of Malta, and President of the Committee of Ministers. Dear Minister Borg, I have already had the pleasure of meeting with you during your visit to the Council of Europe in March last year, and again during the meeting of our Standing Committee in Valletta in May. It is now my pleasure to welcome you to our hemicycle, and we look forward to hearing your presentation of the priorities and planned activities as Malta begins its presidency of the Committee of Ministers for the 4th time in its history, and also in the year that you celebrate your 60th anniversary as a member of the Council of Europe. Dear Minister, you have the floor.
Thank you, President of the Parliamentary Assembly, Secretary General of the Parliamentary Assembly, Secretary General of the Council of Europe, distinguished parliamentarians, excellencies. I am honored to have the opportunity to address you all for the first time in this plenary, in my capacity as President of the Committee of Ministers. In Luxembourg last month, my country assumed the presidency at a particularly historic and consequential moment for Europe. A time when the foundational values of our common European project, human rights, democracy, and the rule of law, are being tested in ways not seen in decades. The ongoing war in Ukraine, the resurgence of authoritarianism, and the rise of disinformation and populist narratives are a huge threat to the very principles that have bound our continent together since 1949. These are not abstract values. They are the building blocks of our democratic societies. They are the legacy of those who, in the wake of conflict, chose cooperation over conquest and dignity over despair. Our task is to uphold them with conviction, especially when doing so is most difficult. The Council of Europe was built to act and to adapt. It has never been a passive institution. Rather, it was born of moral urgency. And in today's volatile geopolitical context, it is precisely this agility that must be protected, strengthened, and supported. Let us recall, the Council of Europe was the first to expel a member state for violating the very values upon which it was built. It has created robust monitoring mechanisms, over 220 conventions, supported the rule of law across 46 states, and consistently raised the alarm when human rights are under threat. It has done so not only in moments of peace, but amid crisis, conflict, and political division. And this agility has never meant compromise. It has meant coherence, the ability to respond to emerging threats without losing sight of enduring values. But agility does not come by default. It depends on political will, clear, collective, and courageous. It relies on the strength of our institutions and the resources we are willing to invest. In such a moment, the Council cannot retreat into passivity. The challenges before us demand unity of purpose and principled leadership. And this is what I emphasized in my speech at the Ministerial in Luxembourg. This is the driving force behind my country's commitment as we lead the Committee of Ministers over these 6 months. That of delivering principled leadership, powered by unwavering political resolve. Together, we can ensure this with determination and purpose. And it is with this in mind that we prepared our presidency priorities. Continuing on what we did in our role as Chair in Office of the OSCE and at the United Nations Security Council, we are keeping Ukraine at the top of our agenda as it continues to face the brutal war of aggression by the Russian Federation. Accountability, justice, and lasting peace are not rhetorical aspirations. They must be structured into our institutional and legal responses. We cannot afford to grow complacent in standing behind Ukraine. But we must continue supporting and advancing the ongoing works, towards justice and accountability, and reminding of the urgency of progressing with the next steps. For Malta, in fact, it was a logical step to steer forward the process for the establishment of the Special Tribunal for the Crime of Aggression against Ukraine. It is an honor that this afternoon I will chair the Committee of the Ministers' extraordinary session to adopt the decision authorizing the signature of the bilateral agreement establishing the Special Tribunal. The signing ceremony will mark a moment of historic and moral significance for every victim of this merciless war. The creation of the Special Tribunal sends a powerful message that the crime of aggression is a grave international offense and those responsible will be held to account for their crimes. It underscores that no one is above the law. And by supporting the tribunal, the Council of Europe, its member states and international organizations demonstrate their willingness to deliver justice, not just words. There is no accountability without justice. Throughout our presidency, we will remain steadfastly committed to actively supporting all efforts aimed at achieving a comprehensive, just, and lasting peace, and to support the action plan for Ukraine's resilience, recovery, and reconstruction. We will also remain deeply committed to countering the rise of disinformation, hate speech, and hate crime, combating violence and discrimination, protecting children and promoting their best interest, safeguarding democracy and the rule of law, and ensuring that the voices of young people are not only heard but meaningfully included in decision-making. In just the first 6 weeks of our presidency, we have launched major initiatives advancing equality, inclusion, and human rights across Europe. We proudly hosted the 12th IDHOT Plus Forum on Sojiesc rights, convened the 4th European Youth Work Convention with over 500 participants, and also held a high-level conference on technology and AI to combat human trafficking. Empowering women and youth remains central to our agenda, demonstrated by numerous events focusing on women in politics, gender equality, and dismantling harmful gender norms. Last week, we proudly also supported the No Hate Speech Week and the Conference on Preventing and Combating Hate Crime, reaffirming our commitment to stand against hatred and promote human dignity and respect. Now, looking ahead, allow me to highlight several key upcoming events. The first ever Ministerial Conference on the Lanzarote Convention, celebrating its 15th year anniversary next week. A Ministerial Conference on Justice in September, where a new additional protocol on mutual assistance in criminal matters will be opened for signature, marking an important step in the modernization of judicial cooperation. The 10th Youth Ministerial Conference in October, to realize the vision of the Reykjavik Summit of implementing a youth perspective with young people engaged as equal partners. And in November, the 75th anniversary of the European Convention on Human Rights, a milestone that calls us to celebrate its achievements, reflect on the challenges, and recommit to defending the rights and freedoms it upholds. And with this update about the presidency priorities, I would like to now brief you about the Committee of Ministers' work ever since your last PACE session, where it has been engaged with a full and demanding agenda. The 134th Ministerial session in Luxembourg on the 13th and 14th of May 2025 this year was a highlight of the last 3 months of activities. This session, which was well attended, addressed a number of issues that also lie at the core of the priorities of the Maltese presidency. Ministers reaffirmed their steadfast support for Ukraine by welcoming the formal letter from Ukraine requesting the initiation of the process to establish the special tribunal for the crime of aggression against Ukraine, and by having created an ad hoc working party, GT Tribunal, which met last week to pave the way for the establishment of the special tribunal. The Council of Europe demonstrated once again its agility and responsiveness. In Luxembourg, the ministers also welcomed the ongoing efforts to reach an agreement on the establishment of a claims commission for Ukraine, and reaffirmed their determination to secure the return of Ukrainian children unlawfully deported or forcibly transferred to Russia. Finally, they also acknowledged the full operationality of the register of damages, and also emphasized the importance of stepping up support for Ukraine, particularly through the action plan. Building on the report on follow-up to the Reykjavik Declaration, the ministers welcomed the Secretary General's roadmap towards a new democratic pact for Europe. The importance of vivid and inclusive democracy to ensure security, stability, and prosperity in Europe cannot be overstated. The core mission of the Democratic Pact is to revitalize democracy, making it more engaging, accessible, resilient, and beneficial to all. And I look forward to the implementation of the roadmap and to the Maltese presidency's active contribution to it through a number of events in Malta in September and October. In a landmark move for global environmental protection, the ministers adopted a new convention on the protection of the environment through criminal law, complemented by a new long-term strategy on the environment and its action plan, aimed at addressing the accelerating environmental crisis through human rights, democratic governance, and the rule of law. Moreover, the Council of Europe Convention for the Protection of the Profession of Lawyer was opened for signature in Luxembourg, gathering already 17 signatories. This is the first ever international treaty aimed at protecting the profession of lawyer in a context of increasing reports of attacks on the practice of this profession. The Committee of Ministers also adopted 2 new essential recommendations to strengthen the protection of the rights and best interests of the child in parental separation proceedings and in care proceedings. These recommendations aim to ensure that the best interests of the child are a primary consideration in all such decisions. And a particularly important point in this regard is that children and young people themselves were consulted in the preparation of these texts, ensuring that their voices and lived experiences informed the content and approach of both recommendations. Furthermore, the second quarterly meeting of the Committee of Ministers in its human rights formation was held between the 10th and the 12th of June, adopting 40 decisions concerning 25 states. The committee welcomed the participation of the Turkish Deputy Minister of Justice, Mr. Akar, in the debate on Kavala versus Turkey, whose attendance followed the 3rd high-level technical visit to Ankara that took place just last May. The applicant, nevertheless, remains regrettably detained despite repeated calls for his immediate release and the court's finding of a violation of Article 464. At the meeting, various possibilities were for implementing the judgment were discussed with a view of achieving results. While the Deputy Minister's participation was encouraging, it remains in the hands of the Turkish authorities to show tangible progress in the implementation of this final judgment. The credibility of the convention system hinges on the implementation of the judgments of the European Court of Human Rights. And it is therefore imperative that all member states, without exception, abide by their obligations and execute the court's judgments. Across our continent and beyond, we are increasingly confronted by actions that erode human dignity and threaten our shared values. In particular, recent political and legislative developments in Georgia have raised concerns within the Committee of Ministers. Following the exchange with key stakeholders of the Council of Europe, held by the committee last March to gain a comprehensive understanding of the situation, the rapporteur group on democracy was tasked to follow up on this and report back by autumn. On the recent matters of discussion at the Committee of Ministers, where the letter signed by 9 states regarding the ECHR system and the situation in Gaza and the Middle East. On the letter, while dialogue remains a cornerstone of peaceful and constructive cooperation and the foundational pillar of effective multilateralism, it is necessary to recall that respect for judicial independence must remain non-negotiable. As regards to the Middle East, this grave deteriorating situation on our doorstep raised profound concern. While the Council of Europe had unequivocally condemned the attacks carried out by Hamas on the 7th of October 2024, the appalling suffering in Gaza that ensued and is still ongoing must not be ignored nor forgotten. Although the jurisdiction and mandate of the Council of Europe is limited to the European continent, this does not mean that the Committee of Ministers remains untouched and unaffected by the multiple serious consequences of this conflict, including the rise of anti-Semitism and anti-Muslim hatred. We cannot deny the far-reaching human rights implications of all that is happening, which fall within the scope of our values and our vigilance. And as this brings me to the end of my report as Committee of Ministers President, allow me to add in my national capacity that this is deeply sobering to witness these and other conflicts unfolding around us. We must not forget that behind every headline are individuals, families, children, communities, whose daily realities are shaped by fear, loss, and uncertainty. We must never lose sight of the deep and lasting toll these conflicts take on ordinary people, people whose only fate was to be born in the crossfire. We must resist the temptation to become desensitized or to accept such suffering as inevitable. Normalizing conflict undermines our shared humanity that erodes the very principles on which peace and justice are built. It is our collective responsibility to uphold those principles and to continue working towards peaceful and lasting solutions. Distinguished parliamentarians, let us protect what protects our values, the standards, the mechanisms, and the moral clarity of the Council of Europe. Let us not take for granted the relevance, agility, and enduring impact of this organization. Because the world may be shifting, but our duty to human rights, democracy, and the rule of law must not. The challenges we face do not stop at the borders, and so neither should our responses. In unity, with unwavering commitment and resolute cooperation, we must rise to these challenges together, ensuring that justice, freedom, and dignity prevail beyond every frontier. Thank you.
Thank you, Mr. Borg. Before I start the Q&A procedure, I would like to remind to my colleagues that there's a vote in progress to elect a judge with respect to the United Kingdom, to the European Court of Human Rights. The poll will close at 1 p.m. Those who have not yet voted may still do so by going to the area behind the President's chair. And the second announcement, I have already spoken this morning in my opening remarks, but now that most ambassadors, if not all, are present, I would like to say that today we celebrate Women in Diplomacy Day. And I want to say that yet globally women remain underrepresented, as highlighted in our 2020 Assembly resolution on the gender dimension on foreign policy. Only 21% of ambassadors worldwide are women. The Council of Europe tells a different story. With 20 of its 46 ambassadors being women, it reaches nearly 44% female representation, far above the global average. Congratulations, dear ambassadors, dear ladies, for the day. And now, I open the Q&A procedure. Dear Minister, I will give first the floor to the representatives of the political groups. The procedure is the same as always. One question, one response, and then I will take in group of three the parliamentarians who have asked to address questions to you. I start with Petra Bayer on behalf of the Socialists, Greens and Democrats.
Thank you very much, Mr. Deputy Prime Minister. No member state of the Council of Europe is perfect, but some infringe our common values massively. Where would you draw this fine red line where dialogue and common efforts is still fruitful to bring countries back to the side of rule of law, democracy and human rights? And where do you think any common efforts and dialogue doesn't make sense anymore and we should better consider different consequences? Thank you.
Thank you, Petra. Minister, would you like to respond?
Thank you. Thank you for your question, Ms. Bayer. And of course, a very important question, Mr. President, because this council is not a club of convenience. It's a community of values, as much as I referred to in my speech, of human rights, democracy, and rule of law. And like any other membership, it clearly entails obligations, and they are not open to interpretation. So whether you are either following those obligations or you are breaching them. In 2022, both the Committee of Ministers, but also your Assembly here, drew a firm and principled red line, referring to red lines, with a historic decision to exclude Russia from this organization. And therefore, it marks how this organization plays a central role in upholding and ensuring compliance with well-established standards. And in most cases, these are codified in rules, embodied in our conventions and also in other legal texts. Yet, I believe that the Council of Europe goes beyond standard setting. It is also an organization that benefits from the expertise of several other monitoring bodies, including the CPT, the Venice Commission, ECRI, Greco, Manival, and here I'm just mentioning few. Again, we are not only about setting standards, but it's crucial to see their implementation, that members are abiding to them. There are judgments, reports, recommendations, findings that are constantly on the agenda of Committee of Ministers. and I also reported in my speech earlier. As president of the Committee of Ministers, I would also like to express the appreciation towards your assembly for its significant role in this monitoring exercise, because your vigilance and engagement is equally critical, and strong coordination and cooperation are indispensable. When it comes to the national position now as well, allow me to underscore the importance of dialogue and multilateralism. I already mentioned our track record, not only in these first 6 weeks of this presidency, but also when chairing the OSCE and serving on the Security Council in the past 2 years. And therefore such engagement should not be construed as an endorsement of the current state of affairs. Rather, it reflects our collective resolve to confront common challenges through principled diplomacy. We will continue to advocate for cooperative approaches, but never at the expense of our shared commitments. So let's hope that dialogue and accountability continue to go hand in hand. Thank you once again for your question.
Thank you, Minister. On behalf of the European People's Party, it's Emanuelis Zingeris. Emanuelis, don't take it personally. I have just forgotten to remind that it is 30 seconds, the time limit. I'm sure that you are going to be in the time limit.
Yes, we see that on the screen. Thank you, dear President. So, my question is related to you, to your very important chairmanship in the most uncertain time when synchronized attack by Russia, China, Iran, Cuba, North Korean totalitarian regime on us are implicated on everyday basis, hybrid attack and others. So, register established and is only in the second phase. How to make quicker the register implementation in The Hague. Second, after these uploads to your site about the court special tribunal will be established, and we uploaded you, dear Minister. So implementation, how will be speedy implementation? 105,000 citizens are compensated by Ukrainian state. How we will compensate through the register the citizens creating foundation for that. And last is, of course, Radio Free Europe. I would like to ask you to send a letter in the name of Committee of Ministers to European Union Commission to finance Radio Free Europe. Well, it's very important to have this item. We discussed this item in the current debates in Malta.
I see that the socialists are complaining, Emanuelis. Thank you. They will accuse me that since I come from the EPP, I gave you more time. Minister, you have the floor.
In this plenary, I see that I can receive many complex questions as well. But I'll try to address because you made many questions in one, and I'll try my best. Look, today we are reaching an important milestone. So when hopefully everything goes well in the afternoon, and during the CM we will get a mandate to the setting up of the special tribunal. It means that just a couple of weeks after receiving the letter from Ukraine, we managed to deliver. And then, as you rightly pointed out, it's a matter of implementation. We should not sit on our laurels. It won't be the final destination. It will just be the start of a longer journey, and rightly so, as I discussed also with the president of this assembly earlier this morning. I am sure that your role, keeping governments in check to implement, to also make the funding and resources available for the actual implementation, be it the tribunal, be it the register for damages, is crucial. And I'm sure that we will continue to walk this journey together in order to achieve and deliver justice, as both sides of this coin, the Council of Europe, would like to see as soon as practicable.
Thank you, Minister. On behalf of the European Conservatives, Patriots and Affiliates, Paul Zablonski. Paul.
Thank you, President. Excellency. It was a very interesting debate on the letter of the 9 leaders about the judicial activism of the European Court of Human Rights. You also referred to it as addressing it as probably not the best way how to approach this matter. But there is a way in the Convention, Article 46, that the Committee of the Ministers can seize the court for a ruling on the question of interpretation. Such a referral decision might be taken by the Committee of the Ministers. And I believe when we speak about expelling criminal illegal immigrants, this is possibly the way to do it. The question is the Committee of Ministers planning to do such a step, to make such a step?
Thank you, Paul. Minister, would you like to respond?
All the time, the microphone, yes. Very, very important question. And I believe that, first of all, we have to keep in mind the importance of the Convention and how well this served our continent, our people, along all these decades that we look forward to celebrate later on this November. Of course, it is also true that migration remains a dominant issue worldwide, including in Europe. And it's good to have an honest, frank, and constructive discussion amongst us. Actions and initiatives, meetings are multiplying on the different European political scenes. And it has been discussed, yes, in the CM as well, and it will surely be in the future. The Council of Europe has relevant capacities, and they should also be used properly in accordance with its fundamental values. I'm sure that the CM, in close cooperation with the SG, who has already exposed some of his ideas in this issue, will make further progress in this topic. And let me mention some relevant figures, what I've seen also today, which gives you an idea about the dimension and the issue, as well as about the trends. So 21% overall decrease in illegal border crossings into the EU compared to this time last year. 69,000 estimated illegal border crossings through mid-June. So irregular migration remains a complex and global challenge that no nation state is equipped to address alone. But yeah, with reference also to criminal groups, to smugglers and networks, mainly also located in countries that are facing uncertain times or instability, like our neighboring country, Libya. We know something about it, and we know how it is important to find ways and means to work with the Libyan authorities on both sides, to work with their coast guards, first of all, to save lives at sea, but equally important to combat the illegal migration network of criminals and smugglers. So it's also true that these criminal groups operate far beyond the Mediterranean as well. And at the same time, we should not compromise the principles enshrined in the convention that basically guided us for all these years. We also note the letter that was seen in public, signed by many leaders, and of course we take note of that. But I will definitely be honest and keep this assembly informed through transparent dialogue with the President, with all those that would like to be briefed. But all I can say once again is that we fully appreciate and support also the Secretary General's initial response to this matter.
Thank you, Minister. On behalf of ALDE, it is Beatrice Fresco-Rolfo. Beatrice, you have the floor.
Merci, Monsieur le Président. Monsieur le Ministre, nous assistons à un recul des droits des personnes LGBTI dans de trop nombreux pays membres du Conseil de l'Europe. Vous voulez peut-être que j'attende ? Nous assistons à un recul des droits des personnes LGBTI dans de trop nombreux pays membres du Conseil de l'Europe, comme la Slovaquie, la Hongrie et la Bulgarie, pour ne citer qu'eux, sous prétexte de protection de valeurs dites traditionnelles. Les récents développements législatifs ont affaibli cette communauté. Plusieurs membres de cette Assemblée ont d'ailleurs souhaité qu'un débat sur ce sujet soit tenu. Que comptez-vous faire durant votre présidence pour réaffirmer et renforcer la dignité et les droits des personnes LGBTI ? Je vous remercie.
Thank you, Beatrice. Minister, would you like to respond?
Thank you for your question. Well, first of all, I think that what our country managed to achieve already explains a lot, not only our national position, but also how much we'd like to convey the best practices and examples to our colleagues around the table in the CM. Because it's true that we are witnessing a rise in rhetoric that erodes human dignity and also challenges the very foundations of our shared values. The CM position, basically, it's essential to recall that discrimination based on sexual orientation and gender identity is contrary to the Convention on Human Rights, and member states, including those you referred to, are of course obliged to guarantee the right of freedom of expression and also assembly, including by allowing pride events to take place. I had the opportunity last month to discuss briefly about this with my Hungarian colleague as well. We have strong strategies in place to counter such backsliding, and the Committee of Ministers' recommendation of 2010 on measures to combat discrimination on grounds of sexual orientation and gender identity constitutes a common base for European countries with no equivalent at global level. In recent years, further steps have been taken as well. In 2022, the Committee of Ministers adopted a recommendation on combating hate speech, and 2 years later, in 2024, a recommendation on combating hate crime. A new recommendation on the equality of rights is also under preparation. In parallel, the European Commission against racism and intolerance monitors these issues and promotes its general policy recommendation, number 17. As Malta we made decisive and sustained progress in advancing the rights of LGBTIQ plus persons. A landmark judgment also of the European Court of Human Rights served as catalyst for fundamental legislative reforms. For the 10th consecutive year, Malta is proud to be recognized as a European leader in this field, but at the same time we are under no illusion, recognizing that we must never breed complacency. In 2023, we adopted the third National Strategy and Action Plan for LGBTIQ plus equality. We outlined 34 targets there across sectors. National efforts are also taking place not in isolation, and therefore through our presidency we will continue to place this issue at the forefront of our agenda. As I mentioned in my speech, we already hosted the 12th IDHOT Plus Forum in Malta. Earlier this year, in September, we will convene a conference on ensuring equality for rainbow families in Europe, and also in close cooperation with the parliamentary platform for the rights of LGBTI persons of the Parliamentary Assembly. So we look forward also to welcome many of you there. At a time when identity is increasingly politicized and weaponized, Malta will definitely stand firm in its conviction. So that is my response, Mr. President.
Thank you, Minister. Sabilai Celenc, on behalf of the United European Left. We cannot hear you, sir. We cannot hear you, Sabilai. Have you inserted your badge first? And press the microphone?
Here? Yes, it's okay.
Yes, it's okay now.
Okay. Thank you. At a time when expectation and hopes for a new peace process in Turkey are rising after the laying down of weapons, but unfortunately the Israeli and Iranian war continues and Syria remains unstable, pressure on the main opposition party, the CHP, is increasing, and many judgments of the court are awaiting for implementation. So my question is, what mechanisms the Committee of Ministers can set in motion to support a secure, stable, democratic order and establish peace in Turkey and the region? Thank you.
Thank you. Minister?
Thank you. Of course, my reply would be the importance of multilateralism and strengthening its role, which is definitely under huge attack at the moment. Turkey is an important partner for all of us. Not least, we have an excellent relationship with the people of Turkey, and it is also at a very particular, it lies in a very particular geographical juncture. I referred in my speech to the Deputy Minister's participation recently, and the fact that we, as Presidency of the Committee of Ministers, will keep urging each and every government and their authorities to not only accept but also implement, execute court decisions, like you mentioned in your question. At the same time, you are aware that this obligation lies within the Turkish authorities' territory, and we will keep making our point with them and ensuring that each and every member state, participating state, is following the obligations of the membership that I referred to the first question I received earlier in this session. Thank you.
Thank you, Minister. So, now I have to open the speakers list. The questions, as I have said, has to be limited in 30 seconds. Dear colleagues, listen. I have 5 requests. The procedure is that I give in group of 3. If the Minister agrees, I would like to give all 5 colleagues to ask questions in 30 seconds each, and then you will have like 7 minutes to respond. Is it okay? Okay. Let's start with Chrysime Grigorian.
Thank you, President. Mr. Minister, during the ministerial session in Luxembourg, a decision was made by the Committee of Ministers on calling on Armenia and Azerbaijan to sign and ratify the peace agreement, the agreement on peace and establishment of interstate relations. And I would want to ask you to kindly elaborate on what steps have been taken to facilitate progress in this matter. And taking this chance, I wish best of luck to Malta's presidency during these trying times. Thank you.
Thank you. Zita Gurmai. Zita, you are second.
Thank you very much. I will be telegraphic. Ethnic violence has been on the rise in European recent time, while more and more European nations consider national minorities living in their territory as a security threat. What can we do to reduce the rising number of hate crimes against our very own national minorities, and what can the Commission of Ministers can play in the respect? And then 3 small things. We are going to have the Equality Committee in Malta, which I'm looking forward. I will be at the Pride because I really wanted to show the dignity is super important. Third, it is very important that feminine diplomacy has got 44% like your own. And then last, new democratic pact. Yes, for the new democratic pact. Thank you very much.
Too fast, too quick. To ask 3 questions. Bravo, Zita. I will ask for the tip later. How do you do this? I was journalist for 20 years, and I never had the opportunity to ask so many questions in 30 seconds. So, Bisera, it's your turn now. Bisera Konstantinos-Katsogevska.
Thank you, Mr. President. Respected Deputy Prime Minister, in view of your priorities as the Council of Ministers President and upholding the presidency, I would like to ask you what means, besides upholding events, has Malta taken into force to prevent violence against women and combat hate speech? Thank you.
Thank you, Bisera. And then it's Armen Gevorkian. Armen. Armen, we cannot hear you.
Mr. Deputy Prime Minister, you know that shameful trials are currently taking place in Azerbaijan against Armenian prisoners. This organization has so far been unable to exert any meaningful influence on the Azerbaijani authorities or to secure a just and dignified resolution of their fate. Why is the Council of Europe incapable of influencing this situation? What message does this send to those around the world who still believe in democratic values, especially at the time when such values are under intense global pressure? Thank you.
Thank you, Armen. And the last colleague is Yevgenia Kravchuk.
Thank you, President. On behalf of Ukrainian delegation and Ukrainian people, I would like to thank Malta for this leadership in coordination of the creation of the special tribunal. The whole process we'll see this week. My question is, where do you see at the end of the year, where we will be with the special tribunal if all these needed steps will happen this week? And as the chair of the subcommittee on youth, what are your priorities as being having presidency of Malta with regards to the youth empowerment, especially with the ministerial conference in Malta in October? Thank you.
Thank you, Evgenia. So, Minister, you have 10 minutes, if you want, if you wish, of course.
Thank you, Mr. President. About Armenia and Azerbaijan, the situation in the South Caucasus. Last year, when I chaired the OSCE, I had the opportunity to meet twice Prime Minister Pashinyan and President Aliyev, because in that organization, the peace agreement is basically keeping the organization hostage when it comes to its budget. And both head of governments were quite clear that they wanted to first see the peace agreement achieved, signed, and respected before moving forward on the Minsk structures. It was good news that earlier this year we saw developments on the peace agreement being reached, but not yet signed. So what we are doing, basically, also 2 weeks ago when I was attending one of the international conferences, it was in Nice, about the oceans called by the UN. I've met the respective delegations asking for updates, what is still pending. I understand that this is works in progress. It's also true that, and I fully respect the fact that Armenia and Azerbaijan would like to keep their talks bilaterally, not including any other organization or third country in those discussions. So we can just hope and wait, because we are so close to this agreement that can mean a lot, not only for the two countries in question, but also for the whole region, of course. And I link the question on the trials in Azerbaijan, and also with the previous question about Turkey and the opposition there. Well, as I said, I mean, we cannot but ask and urge all member states to respect the values that they subscribe to when they joined this organization. Other countries want to join this organization. They know the commitments. If you are in or if you are out of this organization, you know what are the values, the principles enshrined, and therefore we expect Azerbaijan, Turkey, but all other countries, including my own, and no one is exempted or excused from upholding the highest levels of justice and rule of law. With regards to hate speech and hate crimes, as I said, the protection of all individuals, including national minorities, is essential to democratic resilience. And as Council of Europe, there was already action taken, including standard setting, intergovernmental cooperation activities. And in this domain, the Council of Europe Framework Convention is the first legally binding multilateral instrument devoted to the protection of national minorities worldwide. Its implementation is monitored also by the Advisory Committee, which is the only international committee dedicated exclusively to minority rights. Furthermore, the Committee of Ministers has adopted a number of key recommendations in recent years, including the recommendation on combating hate speech in 2022, and on combating hate crime, which includes its investigation and victim support just last year. From a national perspective, we reaffirm our commitment to combat violence and discrimination in all its forms. And this commitment lies also at the heart of our domestic agenda, and it's reflected in our priorities that I refer to also in my speech. In the early weeks of this presidency, we have already translated commitment into action through initiatives such as the No Hate Speech Week, and also the Conference on preventing and combating hate crime held here in Strasbourg. And furthermore, combating hate crime and hate speech, both online and offline, forms as an integral part of Malta's anti-racism strategy. We hope that these efforts are kept very high on the agenda, not only during our presidency, but also beyond. When it comes to youth, thank you for your question as well. Youth is not just one of Malta's priorities under our presidency, but it is a cornerstone of our vision. We believe that young people are not only the future, but active agents of change today, and leaders in today's political spectrum. And in this spirit, we already hosted a major event this year that placed youth at the very heart of our presidency. That was the 4th European Youth Work Convention, as I mentioned in my speech earlier. It brought together around 500 participants from 40 countries, and we explored key themes such as ethics and standards in youth work, inclusive practices that empower young people, amongst other things. And we are also hosting the 10th Council of Europe Conference of Ministers responsible for youth in October. It's important to note that this high-level gathering will review progress since 2012, St. Petersburg Declaration that set the vision for youth policy up to 2030. And also, we are building on the Reykjavik Summit commitments. So we will have this conference that will bring young people at par with the ministers on the same table in Valletta, and in a genuine co-creation, not in parallel tracks. With regards to Ukraine and to violence against women, again, it's a priority for us, and it's not only focusing on the response, but also on prevention. This requires recognizing how gender stereotypes perpetuate cycles of discrimination and violence, and preventing violence at its roots requires that we also recognize how gender stereotypes reinforce cycles of discrimination, exclusion, and harm. These efforts, in my opinion, must be complemented by strong legal frameworks that translate principles into practice, and in this regard, Malta amended its criminal code back in 2022 to recognize femicide as an aggravated form of homicide. Just this week, we took another step forward by introducing panic alarms for persons deemed at extreme danger through official assessment. But violence is not limited to physical harm, Mr. President, and therefore online hatred, disinformation, character defamation, and deliberate distortion of truth are equally damaging. Women in public life, today, as you mentioned, we're celebrating women in diplomacy. Thank you to all the women in diplomacy, which we once again gave example. I had 3 permanent representatives, women, doing excellent job in the Security Council in New York, in Vienna for the OSCE, and here in Strasbourg with the Council of Europe presidency. And on Ukraine's special tribunal, yes, and I conclude, we will continue to seek to advance the next steps, as I referred to earlier question by the Lithuanian member of parliament here. Our role is to encourage sustained political will after today, after tomorrow, when we sign. Hopefully, we can keep that momentum, we can keep that same political will in order to have the critical mass to achieve and ensure sustainable budget and wide participation. These, I think, are the most important steps before us. So we rely also on the Assembly's support to ensure the wide support and participation. So I hope I managed to at least give my answers to your members' questions, and I thank you.
You did so, Honourable Deputy Prime Minister of Malta. Thank you so much. Dear colleagues, before closing, the ballot for electing the judge with respect to the UK to the European Court of Human Rights is now closed. The counting of votes will take place under the supervision of the tellers. I repeat the names. On behalf of the Socialists is Denis Begic from Sweden. On behalf of the EPP, Sergei Vlasenko from Ukraine. On behalf of European Conservatives, Patriots and Affiliate, Axel Kassinger from Austria. On behalf of ALDE, Lucia Plavakova from Slovakia. On behalf of United European Left, Anne Graves from Ireland. I invite them to go to the count that will take place in the room set aside for this purpose. The results of the election will be announced at the opening of the afternoon sitting. The Assembly will hold its next public sitting this afternoon at 3:30 p.m. with the agenda approved on Monday. The sitting is adjourned.